May I please, Your Lordship? Lordship, I beg to mention, Lordship, yesterday list item number 11, Lordship. Today is the 60 days complete, Lordship. Matter may be taken up.
Make a mention before either before AST or before court number 16.
Earlier occasion is rejected, Lordship.
Make a mention before either court number 16 or AST, it may come before this.
Hello.
Item number 1.
Item number 1.
May I please, Your Lordship? My Lord, FIR at page 11, my Lord. On the last day before, it was
It was.
My lord, regarding that
My-
CS report, my lord, that on last on my lord, 22nd, my lord, the matter came, my lord. At that time, my lord, we take the telephonic instruction, my lord. And they stated that, my lord, they're in the last phase and they have already filed it. The report we didn't get, my lord. Thereafter, on the same day, they sent us the report, my lord, electronic
That's
mode,
why it was kept, I think.
my lord.
there is
Mr.
a
Azad, the case has already been charged sheeted. However, I can understand she is behind the bar how many days?
my Lord, today is 82 days, my Lord. As the charge sheet has been submitted, my Lord. So further custodial detention may not be required, my Lord. So I may be allowed to go on bail, my Lord, with surety, my Lord, from this court.
As charge sheet has already been there, so I don't want to pass any order in this condition. So do one thing, we dispose of the matter immediately tomorrow only by tomorrow we can move a petition before the London trial court. It's a it's a case of session tribal, I think, no?
My
That-
lord,
No, not
My-
session trial.
Will be session tribal, my Lord.
Oh, yes, it is with session trial. Part Mr. Ipiazar, Ilani Consultative Petition, Part Mr. A. Bush, Ilani Additional PP, appearing on behalf of state respondent. It is submitted by Mr. Bush that as per the report of the I, the case has already been charged by CS number 251 of 2025, dated 22/09. Mr. Ajad, however, submitted that the accused petitioner is in custody since last 82 days, and hence considering her period of detention, she may be released. As the case has already been charged. Sport, it's often, I do not find it justified to pass any order on bail at this time. However, the petitioner is hereby directed to appear before the learned trial court with an regular application of bail, which may be considered according to observation. The report of the IO be kept as a part.
Publish.
May it please, Your Lordship?
Actually, Your Lordship. Here is second bail application, Lordship. At this stage, my prayer is that, Lordship, records may be called for. And Lordship, that earlier order is there, Lordship, at page 114. Along with that record, Lordship, present case may be listed, Lordship. Page 112. 114, Lordship. 114. Co-accused were granted bail, considering those other materials.
Then we can call for the case record, but obviously it will be after vacation only.
Lordship.
Uh,
Immediately after
Immediately
vacation.
after vacation will do. We are reopening it on 30th, na?
30.
Let it be on 14th or 15th,
Okay.
because 13 may not be
Okay.
reached.
Okay.
I heard Mr. K. Amit, learning counsel for the petitioner, also heard Mr. K. Wood. The learning additional PP appearing on. There we go. Scan copy of the we call for. You, along with what you are submitting.
Along with records available with bail application number 2236 of 25. Page 114.
If we get, then it's okay, or you want to call that?
Lordship can fix along with that record only because that was up to date. I will not pay for that. Only
If we
status
can,
report may be called.
Status report you can
Status
submit
report,
before
yeah.
us.
Yes, I will submit, Lordship. Last order I will submit.
What is bail application number? What was the number?
2236 of 25.
double,
double two,
double two,
Lordship,
36,
36,
25.
25. BA.
Part of history is whether to take the matter along with BA number 22, record of BA number 2236 of the part of the present status report may be all list to be good. List accordingly 14, 10.
Obliged, Lordship.
Please, your lordship.
That is about. Lordship, this matter, we need to obtain some instruction. So,
No, otherwise we have kept this matter for the special drive mediation.
yes,
So what, have you taken, have you consulted with your clients that they are interested to go for mediation and all?
that's what your Lordship. We weren't
You want.
able to obtain instructions. So if the matter
What
comes
about-
up after.
I don't have any objection to it, lordship.
You don't have any. You're,
We-
they are,
We are ready for this.
so you're for the appellant. No?
Yes.
What's your good name?
As Gautam, your lordship.
S. Gautam,
Yes. For
appearing on behalf of Mr.
KK Mount.
S. Gautam, appearing on behalf of Mr. KK Mount. And your good name?
D Khan, your Honor.
D. Khan, D. Khan Vasana. So far, Mr. D. Khan, respond. It is submitted by Mr. Gautam that the appellant has no objection if the matter is sent for mediation. However, it is submitted to Mr. Khan that he is to take instruction from his, the respondents. And accordingly, so some. Considering this submission made by land council for both sides. Let the matter be listed after vacation and then a date will be the history. And considering the, oh, okay, we're listing after it, after vacation, you take instruction. If it is possible, then we'll send it for vacation.
Obliged, your lordship.
Your Lordship, this is not a fit case for mediation, and the LCR has also been received. So, Lordship, the matter may be fixed for hearing.
My lord, we have also filed an IA in this matter, praying for compliance of order dated 4th of March of this honorable court, but that IA is not on record. So my lord may issue directions that the IA may also be placed on record when the matter is listed.
I was there,
IA is not on record today, my lord.
not on record.
Not on.
What was the IA number? Can you tell us?
My lord, we have filed it only on Friday, so we don't have the final number.
Friday,
We have filed the IA only on Friday,
last Friday.
last Friday, ma'am.
Hard MS,
A. Biani.
A. Biani, Dilani Council. You're appealing for KK Bhatta,
Yes, sir. R.K. Bhatra.
RK Bhatra, Dilani Council for the applicant. Also hard MS,
S. Sharma Hazare.
S. Sharma. Your name is here? Your name is, your name is not,
No, my lord, my name is.
not
I'm
reflected.
appearing on behalf of Miss S.K. Nargis.
S.
S.K. Nargis, on behalf of
S.K.
S.K.
Nargis. Appearing on behalf of Mr. S.K. Nargis, sorry, MS S.K. Nargis. And it is submitted by MS Biani that the present case is not fit for sending it some for remediation as there are some law points involved. And in the same time, MS Sharma also submitted that one I has already been filed in this case, which needs to be tagged along with the case. Race to build it needful. Is a matter immediately after vacation and then it.
Much obliged.
This matter.
May I please, Your Lordship? Yes, Your Lordship, this matter is not fit for mediation, my lord. Because my lord, in tribunal, this case was already dismissed, my lord. So this may be heard, my lord.
It was dismissed.
Yes, my lord, in tribunal.
Okay.
Lordship, matter may be lordship fixed on 16 October, lordship. Maybe fixed
No problem.
for hearing.
If TCR come,
See whether it
TCR
can be or
DCP.
not, I don't know.
TCR
You're Mr. Sarkar,
80 sure.
Sarkar, Dilan for the appellant and also part MS L Sharma, the learned counsel for the respondent. It is submitted by, the case is fixed for, the case is, case was supposed to be, so no, case is, for the, referring to the special mediation. But it is submitted by MS L Sharma, the counsel for the respondent, that, in the learned, by the learned tribunal had already dismissed the case, and hence there are some law points involved, which is to be heard before this court. Considering the submission made by learned counsel for both sides, if the matter be listed. 16th and দিব পাৰি
On 16th October.
No, we cannot, just you are
As usual, also.
already came out of here. Huh? Oh, no, not at all possible. Only 10 hearings already been fixed on 16.
Yes.
16, we have already fixed 10 numbers of hearings. None of
Lordship, within October, Lordship. Within October, any date may be fixed, Lordship.
October to I cannot.
Any
say
date, Lordship, within October.
29th of October.
Obliged.
Obliged.
Yes. Yes. What is the position of this case?
Lordship,
And can it be sent for mediation?
Lordship, this can be fixed for hearing, Lordship.
Hearing is okay. Can it be sent for mediation? That's what I'm asking.
That's why, Lordship, it cannot be settled, Lordship, in the,
Why? Why?
in the meditation, Lordship. Lokadat, of course, will try for settlement in the Lokadat, next Lokadat. But in the meantime, this may be kindly fixed for regular course of hearing. Lordship.
No. Why it cannot be settled in the mediation? Is there any other? What is the case you have filed for?
Quantum.
For quantum.
Quantum.
That's what I'm asking. For quantum can be settled in the mediation.
It can be fixed in a Lokadat, next Lokadat, Lordship, December Lokadat. That will we don't know.
No, why not before mediation? The simple question.
No, Lordship.
It is only for quantum. The other some matters are there where law points are involved. It's okay. It may not be said. But why it is only quantum is there only?
But
Quantum
Lordship,
can be settled.
some dispute regarding this disability aspect is there, Lordship.
What do you say?
Lordship, as your lordship wishes, maybe send to mediation. Lordship.
We'll try in the next Lokadat. In the meantime,
Local.
December Lokadat, Lordship. We'll try.
December will come later on. I'm asking for mediation. You are saying
Lordship,
it's not possible for
mediation
mediation. Then
is-
how it can be possible for local alert?
It cannot be possible in the Lokadat, the meditation.
How it can be possible for mediation, local alert? But
Local-
local alert is also for compromise and all only,
Yes,
settlement only.
then it regular course of hearing it may be fixed because LCR has to be come. I don't know whether LCR has come. or
আমরা
not.
দিয়ে বেকার নীতি মানবটাকে হেৰি কৰি থাকে আর মিস্টার ইয়ার আগরওয়াল the learned counsel for the and also part the learned counsel for the spot is submitted by Mr. Agarwal that it is not at all possible to settle the matter before the mediation. In view of this, let the matter be listed in regular courts of hearing. Raised to be fixed as an editorial will be the listed.
If LCR has not come, then
Yes, it will be for hearing.
Okay.
this is also Lordship,
Yes,
same Lord,
this is for quantum.
for quantum Lordship.
No, I'm not following you. If it is for quantum only,
Yes,
why
sir.
why it cannot be sent for mediation?
Because Lordship here also LCR has not come again. And again, this party is not ready to
SCA already received. SCA is there.
receive. Lordship, party is not ready for settlement in the meditation, Lordship.
Huh?
Party is not ready. My instruction is like that only, Lordship.
Lordship, it's on quantum, Lord.
Quantum, that's what I'm asking. It is only on quantum.
Simple injury, no evidence, nothing, just delay the matter. Your
Ah.
Lordship.
No, Lordship,
Now I am appealing for Asana 1 and 2.
The claimants.
No.
Ah.
Till now, I am not furnished with the copy of appeal Lordship.
okay, I'll sign the copy and let
Can
it.
we go for mediation? That can be go for mediation.
I'll give the copy, Lordship, and then let it fix
But
for
what
hearing.
your party says, it can be settled before mediation?
Yes, copy.
The quantum only. Yeah.
No, because he's the owner and driver of the vehicle, Lordship.
Who?
That is my.
You are the claimant.
I am the claimant,
Oh,
Lordship.
see, you are on quantum only.
Yes.
Lordship, but the thing is, my instruction is that, Lordship.
No, your instruction, leave your instruction. Why the reason I am asking why it cannot be? Because it is only for quantum. We have identified some of the cases for mediation because this is special drive is going on mediation.
Yes, Lordship.
Or as per the guidance of the Honorable Supreme
Yes,
Court.
Lord.
That's what I'm asking.
Lordship,
You are saying this
my
is
humble
for
praise,
what?
my humble praise that it may be fixed for regular course of hearing, Lordship. In the meantime, we'll discuss, I'll file the copy. And of course, Lordship will try for a settlement in the, before
Where?
Lokarat also. Before
Where try for settlement?
with the insurance company, Lordship.
Huh?
For discussion, etc., we'll go with the insurance company, Lordship. Then if it possible, then the
There must be
outside
some
court also.
order,
we can settle.
otherwise, there must be some order from this honorable court, then only insurance company will agree to settle. Otherwise, Lordship, if mediation, it will go for mediation. If it cannot be settled, then it will be back.
It will be back.
It will be back.
That's
There
right.
is no problem.
Ladies send for mediation. And Mr. A.R. done the appellant and also heard MSM Chaudhary for the, you are for the,
And for respond number 3,
respond number 3
Oriental Insurance Company.
and also heard Mr. M.I. Hussain, the learned counsel, appearing for respond number 1 and 2. No, 1 and. This is a case for, the present appeal has been filed only challenging the quantum of award and accordingly, and it is to send for mediation. Parties are hereby directed to appear before the mediation on November. November. 6th of November, so and so. The Office of the State Legal Services Authority as well as the High Legal Services Authority will do the needful in appointing mediator on behalf of the parties. List. If it is suppose it returns back, then definitely we can say
Yes,
fix it on for local alert also.
Yes, Lordship.
Otherwise, we are fixing it on 6th of November for the parties to appear.
Must have been
Part of
Your papel lordship may be.
Order, a copy of appeal memo will be served to the respond number 1 and 2. Appeal. If you have the copy, you can do it, furnish it today also.
Okay.
LCR, we have received the LCR also. Yes, LCR is already been received.
In this case, private respondent has not entered appearance as yet. It cannot be referred to the mediation also because we are challenging certain order whereby we had sought formal attachment of certain property of the private respondent with the All India Limited. So I pray that matter may be fixed after the vacation.
I'm appearing for respondent number 2.
This
the-
for
All India Limited. Respondent number 1 was an employee under us. So the money that is supposed to be whole, they are claiming that it should be whole by us because of his superannuation amount and all those things. That is how we are party. Respondent number 1 would be important.
is the private respondent.
Matter will be fixed after vacation if not in.
So what the office note says, it is not yet, sir, notice. Notice on respond number 1. It was the statement taken on the 10/7/2025, still awaited. I think.
Therefore, I'm asking formula after the vacation.
Part Mr. P. Second, the senior learned senior advocate, assisted by Mr. A.K. Gupta. Mr. A.K. Gupta, the learned counsel for the petition.
I'm A. Sharma for All India Limited.
Part Mr. A. Sharma, the learned standing counsel for the respondent number 2. Public the oil. However, from the office note, it reveals that the notice is still awaited for the respond number 2, respond number 1, and the AD card as well as the notice is still not returned to the court. Then the service be awaited. Further, it is submitted by Mr. Second, the learned senior advocate, that there are some offense influence. It may not be sent for mediation. We estimate accordingly After vacation, it will be listed.
Can it be on 17th? Some urgency is there.
17.
17th.
Is the matter according on 17th of October.
But along with the contempt case number 199 of 2025.
Along with contempt case number
199 of 2025.
199 of 2024.
25.
20. 25. Okay, we're listing it on 199 2025. This we have received here,
My lord, not my lord. So that is the scan TCR not received, my lord. In earlier
but
occasion, my lord,
it was listed on last on 89.
my lord,
Then
89,
why-
my lord.
Why it is not yet received?
My lord.
But how long I will wait, brother? There is 108 days. Other accused persons are on bail.
108 days.
Yes.
Then will you submit anything?
My lord, without going through the TCR, my lord.
No, then you have to be careful
It has to
about.
come from where?
My lord, registry will call the.
No. It has to come from this Kamrup Metro.
My lord,
only.
Kamrup Metro, my lord. Kamrup, it
He
should
was-
come actually, my lord.
Huh?
Because it should come, it is from Kamrup Metro
You
and my lord,
say-
online these things are coming, my.
You know what? Oh,
The Lordship will consider my bail, man.
otherwise, as per you, what is the stage of the case? Is there any evidence recorded or
ATM,
pardon?
regarding ATM.
No. Any evidence, etc., recorded till date or not yet? Charge framed or not yet framed?
No, sir.
Not yet.
Sir, Lord, day first,
একটা basic খবর করবো নি?
FIR does not contain my name.
Reminder আর দিয়ে দিও কাকু এবার। If it takes time to নয় আজকে বুধবার। Section 47. All officers silent. We are just inquiring in the sections, just for the time being. Otherwise, he will submit,
My lord,
if you
it's
want
from
to
Kamrup
submit
Metro
anything.
itself, my lord.
No, otherwise, length of detention, Mr. Varasaji is submitting on the length of detention. You
Right.
have to submit.
Further time may not be granted me.
Pardon?
Further time may not be granted. It looks very odd.
Just we are inquiring the matter for time. পেট্রোলটা আহিব নোৱাৰাটো ভাল টাইম
My lord, in 14,
is
my
there
lord, that
14?
is scan TCR received, my lord. I need some time, my lord, go through the same. 14.
for the time being, just for time.
This matter may kindly be passed over for the time being. Senior Mr. Didas is on legs in
My lord,
sport.
we also received, my lord, the CD. This is also volume us. My lord, maybe after some time, my lord. In the meanwhile, my lord, I will go through that also. my lord. Volume CD, my lord.
Okay, we're keeping it.
60.
So, time being, what is 16 now? Was earlier it was received and
Yeah.
updated was called for, I think.
Updated CD was called for.
Yes.
Lordship, my instruction is that Lordship, charges has been filed in this case.
Oh,
So Lordship, let them take instruction that tomorrow maybe fix that. Only instruction, Lordship, that's filed on that.
No, we'll take
Yes,
instruction, my lord. We'll take instruction whether CS is
tomorrow it
filed or
will
not,
be
my lord.
listed. Tomorrow?
Tomorrow, Lordship.
No, my lord, day after tomorrow, my lord. Tomorrow, my lord.
Yeah, but tomorrow we are not going to list.
Tomorrow, my lord.
Tomorrow কই দিও, at least কেতিয়া tomorrow 25. Okay, we're listing it tomorrow.
Obliged.
Lordship, this is an appeal, Lordship, under Employees Compensation Act, Lordship. Disability was assessed by one doctor in his personal capacity, and no medical board, he was not present before any medical board, Lordship, to assess his disability, Lordship. And that disability was, Lordship, also is a premature
Disability
one.
was not properly assessed.
Yes, Lordship. And disability was assessed on the very last date of this during treatment. So in such cases, Lordship, some after completion of treatment, some days are required to assess what the progress is made. But in the last date when he went under treatment, disability was issued. So we challenge that if any disability, it may be treated as permanent, not as a permanent, but a temporary one. These are the main grounds, and compensation of his monthly income was also taken in the higher side, Lordship.
So what was the award?
Lordship, substantial question, Lordship, in page 12, 13.
How many questions you have prepared?
See, we have several
seven.
questions, seven, Lordship.
Hmm.
And if the honorable court finds fit after hearing
So
the parties.
basically your case is that disability was not properly assessed.
Yes, Lordship.
And it was been assessed at the time of during treatment only.
Yes, and the last date of his treatment.
And one more?
See, monthly income was taken 10,600. The owner was not examined to prove the same, Lordship.
These are not the. So what was the ultimately what was the compensation or award?
Lordship, it was
Quantum?
2 lakh, Lordship, 91,682.
2,91,000.
682.
What is the mark for it? We know. Admit for it. Okay, we have marked some of the substantial questions that will be reflected in the order. And your appeal will be admitted. And what is your I?
I have for stay, Lordship.
Permanent disability in case of the limb or what was the disability part?
Fracture of hand, Lordship.
Hand.
Fracture.
So otherwise what he was doing earlier?
Driver.
What was his position?
Driver.
Oh, driver.
Yes.
I in the cycle learning concept daily. Appellant the applicant. This is an application under 41 rule, rate section 156 for stay of operation of the implement judgment and order award. The judgment and award dated 15/7/2020 by learned Commissioner Boxman. The employees instrument compensation code for better sum in EC page number 214 of the code. Considering this submission made by learned counsel for the applicant, the execution of operation of implement judgment and order so is their best disposal of the connected MFA 41 of the code. Okay, it will be state. It will be after. And now number 2 to the section. Oh, you take steps.
Yes.
We'll pass the order. Only now. Only now. For way to buy my bill. Mr. Busho, we have inquired in the office also. They
My
have
lord.
received.
My lord.
So, we'll hear the submission of Mr. Bhattacharya and you can
On
make.
the length of detention. My lord.
No, otherwise, you can submit on your merit. There are forwarding, etc. are there, I think.
My lord.
On that, in that case, on the merit, you can submit. Otherwise, what was the case?
My lord,
It was
this
a
is-
case of?
My lord, it is a my lord, case of my lord regarding that is ATMs, my lord, that is
Huh?
my lord,
Taking?
my lord, theft of ATM, my lord.
Oh, acha, that case.
That case, my lord.
Ha.
That
Yes, Mr.
FIR is on page
Take-
16.
He can
Can
submit.
you please?
Yes, you can submit.
But the FIR does not contain my name. Nothing was found in my
You are not the
Possession.
FIR named.
case 14. Most respectfully begs to state that I have an savings bank account with State Bank of India, Baltala branch, so and so, and having an ATM card issued against this savings account today at around 10:30 a.m. I withdraw cash amount of rupees from ATM machine installed alongside the State Bank of India, Baltala branch, and while getting back the card, two unknown persons standing behind me start harassed in many ways and deceitfully took my ATM card and gave another card of one lady, Rupa Sharma. And thereafter, the miscreants duo immediately left the place. Later, I came to know that the said ATM card has fake one while checking my account. It is therefore appropriate that necessary action may be initiated against the said two unknown persons. Now, my lord, they file an application before the court adding the sections. There also my name does not is that is that your lordship will find at is 33. Application. That application file,
So prayer for IO of, for adding 112 subsection 111 subsection 2B and 113, 111 subsection 3 and 114, these were already added, considering it to be an organized crime. So from where you are saying that you were not there in the name?
first
Because-
thing, my lord, FIR does not contain my name.
That-
Second thing, annexer file, page 31. The application file before the court does not contain my name.
Does that
So the-
contain your name?
Organized crime.
Where from you are saying your name is not there? Where from you are saying, this is an order where IO prayed for adding of those sections.
Yes, my lord, I am showing.
Accordingly, considering the nature of offense, these sections were added. It is not a case of that your name is there or not.
No, a section is not added against me. They did not
How?
pray. They did not pray even for my name to be added.
The-
Annexer 5, page 31. And those name
Page 31.
31. And those whose names are added, they are already enlarged on bail. So these are the two main evidence placed by the prosecution. This is the second occasion your lordship called for the case. Now it will go
Now,
to
just a second, you just want one more thing. When you got arrested in this case?
11-6.
when it was
11-6.
You got arrested on
11/6.
11/6.
Today it is 108 days. Now. So he may be enlarged on bail. You know?
Yes.
Yes, my lord. Here, my lord, that is the FIR dated 2/6/2025. And the date of incident is also 2/6/2025, my lord. And my lord, here, the matter, my lord, came before this honorable court for the first time on 1/9/2025. At that point of time, my lord was pleased to, my lord, call for a CD and fix the date on 4/9/2025. On 4/9/2025, my lord, when the matter came, we got a communications from the end of the police stations that my lord search sheet was filed. And accordingly, that submission was made, my lord. That is the communication what we have received. As per that communication, my lord, that the CS dated on 30/8/2025. And then my lord was pleased to call for the scan PCR, my lord, for the perusal of the same, my lord. So now, my lord, from that onward, my lord, that is from 4/9/2025. For the first time, my lord, scan PCR was called for. Then again on, my lord, 18/9/2025, my lord. And today's date is fixed for, my lord, that is the scan PCR, which is not available before this honorable court. Now, my lord, here we don't have the copy of the CS, my lord. And my lord, that is the present status of the case on which stage, my lord, the case is pending, my lord. Otherwise, my lord, from that is the date of arrest is, my lord, before that, my lord, earlier it is rejected on 28/7/2025. That is, my lord, on, my lord, Annexer 7, page 35, my lord. That rejection order is there, my lord. And my lord, that point of time, my lord, has gone through entire, my lord, the CD, my lord. And considering that submission, my lord, that was, my lord, rejected. Now, the only the thing is that, my lord, we don't know what is the status of the case on present days. Otherwise, my lord, we have that information that is the CS file, man. and the rejected order which is available before this honorable court. From that, my lord, I can make my submission. Other than that, my lord, I don't have my lord,
There
in the
can
record
be-
to make my submission.
Because two parts are there. One is there, they are now insisting that these organized crime, sections of organized crime were not against them.
My lord,
But obviously without procedural CD
my lord.
and CD, what was the sections against whom, what was the section, that is also not there. But it is, but the other sections are also there, I think, when charge sheet was filed.
Right. In the my lord, that is my lord, the when rejected my lord, in page 36, my lord. My lord, in the my lord, the bottom my lord, that is the before the last paragraph, my lord. So it is seen that as per the inquiry, they mainly target elderly persons in the ATM booths and the name of sweeping ATM cards used to withdraw money from the account using those cards. Here, the case of the card is that another person's Rupa Sharma's some name was there, that card was provided. Otherwise, those are miscreants, my lord. Their names are not known, my lord, to that my lord victim, my lord. And my lord, considering the nature and gravity of the offense, I do not find it a fit case to grant the privilege of bail to the present petition. So that was, my lord, that is the observation of your lordship on my lord 28/7/2025, and the matter was rejected. And obviously, my lord, it is from my lord Kamrup Metro. It should come, my lord. Other than that, my lord, maybe it's why, my lord, some reasons, my lord, we don't have receipt.
The CD is not there. Silent. Okay, I'll pass the order.
What is first?
I lord 16, my lord, I made a mistake, my lord. The communication we received, my lord, CS file, but that was in another file, my lord. So I made the mistake. Apology, your lordship.
You are not in interim also, I think.
Not in.
You are not on
Not
interim.
in much.
Only direction we can give that you appear before the learned trial court below better regular. appeal.
Yes, trial court will consider it available.
Yes, that may be the only observation. So CS number to leave. One 2025, dated 3/9/2025, under section 80/3 subsection 5 of BNS. Your petitioner's name is?
Priyanka Tripathi, my lord.
Priyank Tripathi.
Priyank Tripathi.
Priyank Tripathi.
It's
He-
shown as
he is
absconder, my lord.
Shown as an absconder.
Absconder.
Showing the present this petitioner as an absconder. In view of this, the petitioner will take necessary steps in appearing before the learned and would so. Okay, will observation is there, you can appeal.
My lord, this communication may be kept as a part of
Yes,
record, my
may be kept as
all the
part.
communications, and earlier also I failed, my lord, to make this submission.
Generally, we kept in record, but
My lord,
question should be.
yes,
Okay.
obliged, obliged.
Process just now asking.
Yeah, please.
Ask Mr. Yes, what is it?
This is my first appeal from orders against the order dated 9/9/2025, passed by the Court of Civil Justice Senior Division number 3, Kamrup Metro, in this case number 744/2017, arising out of the title suit number 380 of 2014, whereby the temporary injunction application was dismissed. My lord.
Where's the order?
My lord, the order is at Annexure 7/137. The parties are brothers and sisters. I am the original plaintiff in the title suit, and they are,
You are the plaintiff.
I am the plaintiff. My lord, the facts of the case are that, my lord, there was after our parents, my mother owned some self-acquired property in Dhubri, and my father owned some property in Guwahati. The dispute is respect to the family settlement arrangement, which was executed after their demise. Plus, in that family settlement, when the respondent number 2 is the brother, he had executed a draft agreement. And in the draft agreement, there were some recitals and some clauses, which was later fraudulently entered by him at the time of final execution of that agreement. That agreement is at page. Will you come to page number 26, my lord?
Please.
Page number 26, my lord. Well, when the draft agreement was shown to me, I was agreeing with it. But when the final execution was, deed was finalized, that time the respondent number 2 fraudulently inserted few recitals and a clause. One of the recitals is, my lord, is at page 26. Your lordship has it? And they, plus may I read, and their mother, late Monora Begum, wife of so-and-so, predeceased her husband on 8/4/1998, was the exclusive and possessor or owner and possessor of a plot of land so-and-so of Dhubri town and district Dhubri with 2-storied RCC building measuring about 1,300 square feet and so-and-so in Schedule D, who during her lifetime gifted the entire plot with building orally in favor of her son, only son, A.M.M. Mustafizur Rahman. My lord, this person is the respondent number 2, my lord, who got his name mutated in the record of rights to which the other parties have no objection and consented for mutation in his name. Manoj, now the matter in issue in this suit was that, Manoj, at page 29, Manoj, at clause number 6, Manoj, the last clause, which I prayed for an injunction with respect to this clause, Manoj, that clause number 6, that the party number 1, 2, and 4 within next 5 years from this day shall construct their independent staircase for their own use within their allocated portion of land, for which the third party will bear 50% of its construction cost. This clause and the previous clause were inserted later. Then I was compelled to file a suit for rectification of this deed. Along with it, I had a prayer for a permanent injunction. Then along with this suit, I filed an application under Order 39(1)(2) with respect to the roof of the RCC building. There is an RCC building in the Guwahati property where there is only one staircase, which is a common staircase. It goes to my share of the property, my lord. I stay in the first floor. So there was an ad interim injunction given at the time of filing of the suit, my lord. The order is at 56, page number 56. If I will read the last paragraph, my lord. The plaintiff alleges that since 15/9/2014, the defendant number 2 has started to construct upon the roof of Schedule B building, encroaching upon the share of the plaintiff. The defendant number 2 is also threatening to carry out construction over the Schedule C land. The plaintiff also alleges that the defendant number 1 and 2, both of whom reside in Dhubri, are hatching a conspiracy to deter the plaintiff from her enjoyment of the share of her over her both parental and maternal properties. The plaintiff has thus filed a separate injunction application seeking ad interim injunction restraining the defendant number 2 from carrying out construction upon the roof, encroaching the share of the plaintiff as described in the Schedule B, as well as over Schedule C land, and further restraining the defendants from alienating and changing the nature and features of the Schedule D land till the disposal of the suit. I have gone through the plaint and the annex documents looking at the allegation of the plaintiff and the urgency shown by her. I am of the considered opinion that some ad interim injunction direction should be passed at this stage, at least till the next date, for protection, preservation of the suit property, particularly Schedule B roof. Needless it to say that the defendant shall get an opportunity of hearing in connection with the ad interim direction on their appearance. So there was a status quo order with respect to the roof of that building. In that order was passed and it was made absolute in 2017, my lord. Thereafter, my lord, during 2017, the defendant number 2 started insisting that there is a clause for me to construct my own staircase. So he started threatening that I will destroy the only staircase because you have to make your own
Status
staircase.
quo order was made absolute.
Absolutely.
When?
Whereas it was made absolute.
If it is made absolute, then the injunction petition is already disposed of on that day, or?
No, but when an interim injunction was granted, later it was extended from time to time. And in 2017, it was made absolute. So there is a status quo order with respect to the roof of that building, my lord. So thereafter, my lord, what happened? The defendant started threatening that I will demolish the staircase because I have to make my own staircase as in terms of the family arrangement, my lord. So I had filed an application. That application was heard and the injunction was rejected by the learned trial court, my lord.
But the absolute, your status quo made absolute in regards, in respect of the roof.
Roof, only the roof.
That case, the staircase was not there?
No, that time, because in terms of the agreement, according to the defendant number, I have to make my own staircase within 5 years of that, in terms of that agreement. But my main challenge in the suit is that, my lord, that this clause was inserted fraudulently. So the prima facie case had been found. So I had filed an application in 2017. This appeal is with respect to that application, my lord. Whereas the order is at 137 annexure, the judgment. Now, I'd like to draw your lordship attention to the finding of the learned trial court. What is at page 144. But the written objections was filed, it is with only respect to the respondent number 2, because he was only threatening that the staircase falls in his part, so he's going to destroy it. And he had built his own staircase from the separate entry. So the only staircase which leads to my portion of the property, he was threatening. So I filed an injunction application. He contested the application, and the observation is at page number 144, Milan. The paragraph 15. From the above discussion, aforesaid discussion, it seems that all the claims of the plaintiff have been denied by the OPs. Hence, at this stage, without engaging in formal validation of the documents or the substantive merit of the case, the court identifies a prima facie case supporting the petition. So prima facie case was found, Milan. The injunction was rejected only on the basis of that balance of convenience is not in my favor and it can be compensated in terms of money. So, my lord, may I kindly come page 146, my lord. At paragraph 21, OPs have denied the claims of the petitioner by basically stating that there was in fact a family settlement between all the siblings, and on the basis of such family settlement, the staircase in question is in the share of OP number 2. The OPs have also consented that as per the family settlement, the plaintiff has to construct her own staircase in her own share of land. Though the grievance of the petitioner is against the OP number 2, but the OP number 1 has supported the contention of OP number 2, that the petitioner has no right over the present staircase in question. Moreover, the petitioner has admitted the execution of the family settlement and the insertion of clause 6 in such deed of family settlement. That is, the learned trial court came to an absolute erroneous finding because I have never admitted to the insertion of this clause. In fact, my bone of contention in the suit is for the rectification and deletion of this clause in the family arrangement, my lord. The next para, the present proceeding under Order 39, Rule 1 and 2 of CPC, and hence the same needs to be decided on the basis of 3 cardinal principles of law of injunction. Now, the bone of contention between the parties is regarding existing staircase of the Schedule B property. The main suit is also filed for such partition. In the present circumstances of the case, the issue of such partition is a matter of which needs due consideration in the main suit, and pending determination of such issue of partition amongst the legal heirs of late Abdul Rahman, any restraining order against any of such legal heirs may cause irreparable harm and difficulties to the other legal heirs. Accordingly, any such restraining order at this juncture may cause loss and harm to the present OP number 2. When the OPs have categorically stated that the petitioner as per her share needs to construct her own staircase. The present prayer of the petitioner is not such that the same cannot be compensated by way of money at the end of the trial. If the suit is now, my lord, the only staircase which leads to my portion of the, if it's demolished, my lord, I have nowhere to go. There is no permissible space to construct my own. And this clause was inserted. This is the main suit. This is the clause which I have challenged in the trial court. and the learned trial court having found a prima facie case, they said that it can be, if the staircase is demolished, it can be compensated. Well, how can it be compensated, my lord? Well, and when there was an interim order which was made absolute with respect to the rooftop, my lord, the trial court should have given a status quo order in respect to this staircase also, my lord. That is my submission, my lord. And also, my lord, there is a settled law that every co-owner has a right to use the joint property in a husband-like manner, not inconsistent with similar rights of others. One is that relying on a judgment of the Honorable Supreme Court, my lord. That the last third page, page 71, 751, my lord, the point number 1, my lord. The lordship has it?
Last week,
Last page, 751.
yes.
A co-owner has an interest in the whole property and also in every parcel of it. My lord, now your lordship may have at point number 6. Every co-owner has a right to use the joint property in a husband-like manner, not inconsistent with similar rights of other co-owners. Therefore, my lord, at point number 7, where a co-owner is in possession of a separate parcels under an arrangement consented by the other co-owners, it is not open to anybody to disturb the arrangement without the consent of others, except by filing a suit for partition. Whereas at para number 10, it is thus evident that when a co-sharer is in exclusive possession of some portion of the joint holding, he is in possession thereof as a co-sharer and is entitled to continue in its possession if it is not more than a share till the joint holding is partition. My lord, the suit for partition is pending, my lord. So I had this demolition of the stairs would mean I will be out from the enjoyment of the property, my lord. And all the learned trial court could have given a status quo order, my lord. There is another judgment of the Honorable Supreme Court I'm relying, my lord, where status quo was granted for the preservation of the property, my lord.
But rightly or wrongly, there was a provision in the this deed, in fact,
My lord.
that the respondent number 2 or the defendant number 2 will make the will construct his own staircase. Own
No.
staircase.
Yeah, my lord.
So if there is no staircase and if you are restrained the respondent number 2 from using those stairs, then how he will go?
No,
If that is the position, suppose,
my lord.
if you are not allowing him to construct his staircase and you, by the time you are restraining him from using that staircase, how he will go?
No, my lord, I'm not restricting him. There is only one staircase which he is
No,
going
by
to
the,
destroy.
by through the prayer of your restraint, what was your prayer?
Not to
restrain-
demolish the only existing staircase, my lord, till the disposal of the suit.
But earlier there was a status quo order on the
With
rooftop.
respect to the rooftop, only to the rooftop. I am with this application, I am challenging the restraining order. I'm seeking for a restraining order with respect to the demolition of the only staircase, which goes to my share also and to the share of the respondent number 2 also. He was going to destroy the only staircase because there was an arrangement that I have to construct my own staircase after 5 years from the deed. But that clause of the deed I was challenging, my lord, because I said this has been inserted fraudulently. So the learned trial court had found out a prima facie case that these are subject matter of evidence. But on the ground of balance of convenience and the irreparable harm can be compensated in monetary terms, the learned trial court had dismissed the injunction application. Now, if that only staircase is demolished and destroyed by the respondent number 2, well, my entry, ingress and egress will be stopped. It will amount to ouster from the enjoyment of the joint property. Well, at least a status quo order could have been given. And in fact, my lords, may kindly come to No, in fact, the respondent number 2 has said he has no immediate plan to demolish the staircase in his own submission in the written objection which he filed, and the court has, Learned Trial Court has taken note of that fact. But still, the Learned Trial Court went on to dismiss my injunction, my lord. Well, with respect to the status quo to be maintained amongst the parties till the suit for partition is decided, my lord, I am relying on one judgment which I have.
Yes, it is already.
Yes, my lord. My lord, may kindly come at page number 384. At paragraph 24. We are satisfied from the materials on record that a prima facie case has been made out by the appellant trust as to the agreement for sale, which has to go to trial. Whether there was a concluded contract or not between the appellant trust and respondents, 1 to 8 is a matter of evidence and can only be gone into during the trial of the suit. This brings us to the all-important question as to whether the balance of convenience and inconvenience lay in favor of the grant of an interim order of injunction in favor of the appellant trust, as to whether the appellant trust would suffer irreparable loss and injury if no such interim order was passed. One is that paragraph 25, although it has been submitted by Mr. Nariman as well as Mr. So-and-so, that loss, if any, to the appellant trust could be compensated in terms of money. The said submission does not appear to hold good in the instant case. Equally important is the question of balance of convenience and inconvenience, since the principal object of the appellant trust in wanting to acquire the suit property was to extend its school unit at Kolkata. If the suit property is allowed to commercially exploit it by raising multi-story structures thereupon, the entire object of the suit filed by the appellant trust will be rendered meaningless, and the purpose for which the suit has been filed would be completely defeated. In such circumstances, we are of the view that this is one such case where an interim order is required to be passed to maintain the status quo of the suit property during the pendency of the suit. So, my lord, my entire challenge to the case is that this clause was never, I was not supposed to make my own staircase, my lord. That clause has been inserted in the family deed, fraudulently inserted, and now he's going to, because that stairs falls in his part and it's only the common entry to the rest upper portion of the building, my lord. Now, if he breaks that, because he has his own portion to construct a staircase, my lord. So now he's going to destroy, and my entry to the first floor of the building will be stopped. So, the entire object, my case is that, my lord, this clause is fraudulently inserted by the respondent number 2. So a status quo could have been maintained.
So, without demolishing the present staircase,
Yes,
we
ma'am.
can also construct another staircase? But
In
it
that,
is not
the
possible.
repairings can be done, my lord. The repairings, he's saying that condition is very bad, so I can do the repairings and all. But at that time, he was threatening that I will demolish and I will construct my own staircase from my side. But if that staircase is demolished, my entry will be stopped, my lord. That was my only prayer for an injunction before the Learned Trial Court, which was rejected, my lord. Unless the status quo could have been granted, my lord, with respect, and the suit is at a evidence stage, my lord. The plaintiff evidence is about to commence, my lord. And in his own admission, he has said that I am not going to demolish the staircase. That is my humble submission, my lord. My appeal may be admitted, my lord. The notice may be issued, my lord. I have a IA for an ad interim injunction also, my lord.
It should be before order. You are Mr.
N. Patiri.
Mr. N. Patil. This is an appeal under order 43, rule 1, sub-rule small part, and 2, section 104 of CPC against the judgment and order dated 9/9/2025 passed by the Court of Civil Justice Senior Division number 3, Kamrup Metro in Miss case number, means a case number. It is a order of Kamrup Metro or Dhubri.
Kamrup Metro, my lord.
No, you are saying that Dhubri
Dhubri
property.
is because the family settlement deed, the Dhubri property was also included in that deed, my lord.
J, arising out of disbursement number 380 of 2024, 14, whereby the temporary injunction application under order 49 rule 1 and 2, Federal section 151 was dismissed. Considering this submission made by Mr. Patel, the Learned Counsel, appeal is admitted, issue notice to the respondents to register in energy process. Also call for the as we have this the matter immediately. Okay, I'll pass the order in I.
My lord.
Hate the order because it's not to that extent. Yeah.
Deeply grateful.
In this matter, my lord, city received my lord. My lord, earlier, my lord, when the the matter was came up before this honorable court, my lord. That was my lord, my learned colleague, my lord, Mr. P. Bordhakur, who was appeared on that point of time, my lord. Mr. Bordhakur is today also available, my lord. But my lord, he used my lord intake with some other matters, my lord. In my learned, the senior has no, my lord, he allows us. The matter may kindly be fixed tomorrow, my lord. Mr. Bordhakur, he will appear in the matter, my lord.
But since 27, I'll not be available, so everything has to be completed by 26. So all matters, if we fix by tomorrow, then may again create some problem.
Always 61 days.
62.
Anyway, tomorrow you insist we are for tomorrow.
My lord.
Okay, then we are fixing it tomorrow at least tomorrow. List on 20.
The interim bail was granted by Supreme Court in one of the matter. Anticipatory bail where your lordship was rejected, not in contractors. I think your lordship is aware of it.
No, I'm not aware.
There was a contractor also which was moved.
Yes,
Contractor.
yes.
The lordship knows. Finally see that.
No,
And-
the anticipatory was granted.
Yes. Interim bail was granted. Interim bail was granted in receipt of contractor.
For the
Your lordship
contractor.
has rejected one contractor. Mr. Mahajan has moved it. Just recollect your lordship that one of the contractor,
Yes.
he arrested and one contractor was moved. Anticipatory bail, contractor. And your lordship rejected the same ground, but he moved the Supreme Court and there was, I think, interim bail is granted, I think. Your lordship will
Yes,
take up,
interim in a sense.
lordship will take up
What
tomorrow.
can we see in station?
Same case, man.
Be arrested.
Yes, same case. Re-arrested.
Can be considered as one kind of interim.
I'm sorry, madam.
Can be considered as one kind of interim.
Yes.
And
One kind of interim, my lordship. Because he is 63 days. I told your lordship, my lord. 63 days, I think. And let him, tomorrow he'll argue. Suicide note has already been recovered. It is with lying with them. Entire case will depend on that. Of course, there are some witnesses. But where is suicide
most
case?
probably those some telephonic these things are the conversations where those were sent for FSL, I think, for examination. That part was there. Otherwise, there are investigation or to some extent was there. We'll see to it tomorrow.
Yes. Your lordship can keep if your lordship one day.
Yes, we can see. It will record.
Puja, is there some interim protection? I don't know, my lord. I definitely it is a discretion of the court. We can't say anything. I'm deeply obliged.
Obliged.
This is an appeal by the claimant for enhancement.
for enhancement.
Enhancement.
So who are the respondents? Only insurance company or
Oh, no, there are two insurance.
owner is also there? Two
Yes,
insurance
there are
company.
two insurance companies. There
Acha,
are
acha.
two vehicles involved.
Or two vehicles. So you are basically for quantum.
Quantum.
Part Mr.
A
A.
Bhattacharya.
Bhattacharya, Dilani, the applicant. This is an appeal under section 173 MPH against the judgment and order dated 2106 passed in MSC. Case number 952 of 2021 by learned member MSC number 1, Kamrup M. Guwahati for enhancement of appeal is admitted. Issue notice today to all the respondents to register AD and
My lord,
steps. Yes.
can I take steps by registered code only? Because there are so many respondents. Let me first take by registered.
To register as usual. Look at register. Listed matter accordingly after. We are listing it after.
Oblige.
May it please your lordship. Here, my lord, deceased was riding a motorcycle, my lord himself. That belongs to my lord respondent number 2, my lord.
Respondent 2.
Vehicle belong to respondent number 2 and deceased in this case was riding himself. He lost control, he fell down and he succumbed to the injuries, my lord. Basically, he stepped into shoes of the owner, my lord, not a third party. Self-driving case, my lord.
But the this belongs to number 2.
Number 2. And apart from that, my lord, apart from this ground, the petitioners filed under section 163A and the
Petition.
163A of the MD Act, my lord. So there is a cap of income of the deceased, annual income 40,000, my lord. Now here in this case, my lord, monthly income was assessed at 8,000 per month. Despite there being a bar of 40,000 cap, my lord, annual, my lord. But here, my lord, 163 application, my lord, monthly income was assessed as 8,000.
Monthly.
Monthly. Two grounds, my lord, not a third party and the other ground. Basically not maintainable. Petition was not maintainable, my lord.
One more. I is also there.
I is also there.
What was the quantum of award?
My quantum, my lord. It is, my lord, 12 lakhs 19,400 rupees.
Hard Mr. T. Kalita, the learned counsel for the appellant. This is an appeal under section 173. MPH against the judgment and award dated 19/6/2025 passed by so and so member of so and so. Submitted by Mr. Kalita that the present appeal has been filed basically on the ground of maintainability. Like that. Appeal is admitted. Issue notice to all the respondents to register AD and as it list a matter immediately application as on edit to. Okay, we are admitted this one. And what is for I for are you ready for in regards to payment, what was you want 150% you are ready?
In fact, lordship has given judgment perhaps on this point, my lord. This is self-driving case. This is not maintainable, my lord, because he's not a third party.
Then do one thing.
Till returnable date, may I pray for staying the judgment till returnable date, my lord. I'm not praying for stay till disposal of the appeal, my lord. Till returnable or the other side appears, my lord.
Part Mr. T. Kalita, the learned the applicant. It's an application under 141 Rule 5 CPC for stay of operation of implicit judgment and order dated 19/6/2025 Is submitted by Mr. Kalita. Basically, the appeal has been filed on the ground of independent. Hence, it's submitted that the operation of the improved judgment and amendment may be stayed. May be stayed according to the disposal of. So it's connected. Considering the submission made by Learned Counsel for both. For Learned Counsel for the appellant, relate the operation of judgment and award dated so and so be stayed till next date of listing. Next date of listing. Six. The matter may be listed along with connected.
I will take steps in IA also, my lord.
I have to step up. So we are fixing it after vacation, Puja.
My lord, my lord. Much obliged.
Make decision. Lord, this is a second appeal by the defendant, Lord.
By the defendant.
By the defendant. But I've proposed the questions at page 8, Lord. But before that, if I may just quickly show your lordship the prayer in the plaint. Page 18.
Page 18.
18.
Yes.
Now, para 15, your lordship finds the reliefs. A is, of course, declaration of right title and interest. B, your lordship will mark a decree be passed declaring that the registered gift deed 3576 of 1983 is a forged deed and has no validity in the eye of law and is liable to be cancelled. Now, this deed of 1983 was executed, allegedly executed by the plaintiff's father in favor of the defendant's father. So this deed was challenged. And then your lordship finds that para C1, decree be passed to deliver khas possession of the suit land. So the entire case was that the gift deed executed by their father in favor of my father is actually a forged document, and that gift deed should therefore be cancelled. That's the suit. Now, we of course filed a written statement. We said that the gift deed is genuine, and in any case, it is barred by limitation because it's the deed of 1983. And admittedly, we are in possession, and which is why you've claimed for recovery of possession. Now, at page 26, your lordship finds the trial judgment. Now, among the many issues framed, page 36, your lordship finds the issue pertaining to limitation. Para 21, as your lordship found it, at page 36, para 21.
Yes.
The defendant pleaded that the present suit is time barred as after lapse of 33 years, the plaintiff filed his false and concocted case and tried to establish the false claim. The plaintiffs inter alia sought for recovery of possession of Schedule B land of the plain from the defendant on the basis of their title thereto. Recovery of possession being the principal relief, the present suit shall be governed by Article 65 of the Limitation Act, for which the period of limitation is 12 years and the time begins to run from the date when the possession of the defendant becomes adverse to the plaintiff. However, the defendant did not claim adverse possession in the suit land. In the absence of any specific plea of adverse possession, the suit must be held to be filed within the period of limitation. So the court totally lost sight of the fact that there is a prayer for cancellation of that deed, that unless that deed is cancelled, there can be no declaration of title or recovery of possession. And the correct article, as your lordship knows, is Article 59, that is 3 years. Now, the trial court applied the wrong Article 65 and totally lost sight of the prayer B, which is concerning the deed. Now, if your lordship next has the following page, that is right title and interest over the suit land. Now, within this issue, that validity of the gift deed was also gone into. Now, the following page at page 38, if your lordship sees, para 25, Lord.
Yes. Yes.
The plaintiffs have exhibited the certified copy of the registered gift deed 357683 dated 7/6/1983 as Exhibit 2. PW 4 Bharat Chandra Das, being extra writer, Office of the Deputy Registrar Borpeta, has duly proved Exhibit 2 and stated that the same was issued from their office. From the evidence of the plaintiffs, it can be inferred that the plaintiffs have right title and interest over the Schedule B suit land. The above evidence of the PWs remain unchallenged, unrebutted, and the evidence of the PWs goes to show that the plaintiffs have right title and interest over the suit land. Accordingly, this issue is decided in the affirmative. Now, page 39. The gift deed has also been cancelled. Now, the main moot issue was whether the gift deed signatures in the gift deed are forged or not. Your lordship will not even find a single discussion whether regarding any finding of forgery. But notwithstanding that, they have declared right title and interest, and the gift deed was also cancelled.
No, gift deed was cancelled on what basis?
No finding at all regarding. They only say that the evidence goes unrebutted, so therefore the gift deed is cancelled.
No, one line is there in page number 39 that gift deed number so and so, which is a forged deed.
Yes.
And has no validity in the eye of law.
Yes. Now, your lordship will not find any discussion whatsoever starting from page 34, my lord.
Findings that
Is
the
regarding
gift deed is
forgery.
forged.
Regarding forgery, nothing.
That was the order of the munsif. And
That was the order of
concurrent
the-
order was there.
Yes. Now, my lord, the problem arose. We did not file the appeal within time. So therefore, we took our specific ground was that the advocate did not really cooperate. We weren't even aware of the judgment, and we filed the application for condonation of delay in preferring the first appeal. Now that order was application was rejected by an order dated page 60. Now relevant portion is at page 65. Paragraph 15, my lord. These certified copies of the orders in title suit so-and-so shows that the petitioner contested the suit by filing written statement on 7/10/2016. As mentioned, judgment was delivered on 29/9/2022 after about 6 years of filing the written statement. But the petition filed by the petitioner is silent as to why the petitioner did not take any step against his engaged counsel if the engaged counsel was not conducting the trial properly during this long period. There is no satisfactory explanation by the petitioner about the steps taken by him while his engaged counsels repeatedly avoided to update him about the status of the suit. Being aware of the pendency of the suit, it was the duty of the petitioner to remain vigilant about the progress of the trial. Failure to do so for a period of 6 years only means that the petitioner was negligent and inactive. Now, the basic fallacy in this is, my lord, it's a delay condonation application. So I have to explain the delay from 29/9/22, that is the date of judgment, till I file the appeal. Now, the entire focus of the learned appellate court is my conduct prior to even delivery of the judgment. Because it says that after written statement, I did not conduct the trial properly. That chapter is over, my lord. What I need to explain is what did I do after the delivery of the judgment. So the entire
what was the delay period of delay was there?
Period of delay was, my lord, the judgment was delivered on 29/9/2022. The certified copy was procured on 4/1/25 and it was filed within 30 days, 21/2025. So there's nearly a delay of 2 years and odd month. Now, my lord is aware of that law where it says that when a delay application is dismissed in preferring the first appeal, it amounts to dismissing the first appeal and therefore a second appeal would lie.
That is there.
Yes. In fact, it is available in the record, which was Shyam Sundar Sharma. It is Asera.
So you have already supplied?
Yes. So now, my lord,
Shyam Sundar.
Shyam Sundar Sharma, this is 2005 1 SCC.
Yes.
So that clearly says that if you
Which para? This is.
para 8 to 10. Paragraph 8, the question was whether it will be a decree. The Supreme Court said, para 8, my lord. The first question is to be considered is whether an appeal accompanied by an application for condonation, condoning the delay in filing the appeal is an appeal in the eye of law. When the application for condoning the delay in filing the appeal is dismissed and consequently the appeal is dismissed as being time barred in view of Section 3 of the Limitation Act, there was conflict of views on this question before the High Court, but the Privy Council in so and so held. There's no definition of appeal in the CPC, but their lordships have no doubt that any application by a party to an appellate court asking it to set aside or revise a decision of a subordinate court is an appeal within the ordinary exception of the acceptation of the term, and that it is no less an appeal because it is irregular or incompetent. Para 9, my lord. The specific question involved came to be considered by this court in Melaram. This court held that an appeal presented out of time is an appeal, and an order dismissing it as time barred is one passed in an appeal. The court referred to and followed the view taken by the Privy Council and by the court of the two respective decisions. The Lordship can skip over to para 10. The question was considered in extenso by a full bench of the Kerala High Court is Thambi versus Matthew. Therein referring to the relevant decisions on the question, it was held that an appeal presented out of time was nevertheless an appeal in the eye of law for all purposes, and an order dismissing the appeal was a decree that could be a subject of a second appeal. It was also held that Rule 3A of Order 41 of the Code did not in any way affect the principle. An appeal registered under Rule 9 of Order 41 of the Code had to be disposed of according to law, and a dismissal of an appeal for the reason of delay in its presentation after the dismissal of an application for condonation of delay is in substance and effect a confirmation of the decree appealed against. Thus, the position that emerges on a survey of the authority is that an appeal along with an application for condoning the delay in appeal, in filing that appeal, when dismissed on the refusal to condone the delay, is nevertheless a decision in the appeal.
Because otherwise, it
Yes.
seems that it can be termed as a, it's a
Order.
bad-
Yes, yeah. It becomes a decree then. My lord, your lordship is rising. Your lordship is rising.
For 5 minutes.
Yes.
So
Pro-
here you
uh,
have also prepared your.
Yes, page 8, madam.
Page 8. Okay, we'll come just for 5.
Yes. Lord. Two perhaps will not press, my lord.
Two, you are not going to. You know?
No, two may not be necessary.
65 is there one, na?
Yes.
Regarding Article 65.
Article 65 wrongly applied. If number 4 is
For forgery, they have produced some
nothing, my lord.
kind of.
My lord, at least in the judgment, there is nothing. Judgment, if your lordship sees, trial judgment, there's absolutely nothing, no finding regard forgery. Why I had taken your lordship to para 38 was because on the other hand, para 25, they said it has been duly proved exhibit 2. And exhibit 2 is the give gift.
No, duly proved means that deed was exhibited.
Yes.
But regarding the forgery, it is a forged deed. What was the proof?
There was no finding at all. That is what I find surprising. When I have read the entire judgment, there are no findings regarding forgery.
Okay. Comment. Oh. Juga tidak. Itu bohong gitu. So, sila dito. Oh, formal lang ako pa sila. Formal, just pass. No. Iba dia yun. Part needs to be detected and responsibility. Applicant. Since connected to the provision 100 CPC. Each achievement and declared for 8/2025. Passed by the civil just senior division for better. In the case number 15 of the 2025, there has been of title appeal number 13 of the 2025. Dismissing the application for conservation of the and thereby dismissing the decree on the ground of limitation and affirming the judgment and decree dated 29/09/2020 passed by Learned Civil Judge Junior Division number 1 for in TS number 96. It is submitted by Mr. Deck that the basically the appellant was appeared in the title suit number 96 of 2016 as a defendant, which was instituted by the respondent as a plaintiff for declaration of the guilty, which was executed in favor of the defendant by the father of the plaintiff, and also paid for recovery of transportation. The said title suit was this decreed in favor of the plaintiff by declaring the rightly interest in favor of the plaintiff respondent, and also made a declaration regarding that the deed which was executed in favor of the defendant was voted, but without any findings regarding the forgery of the deed, as well as without confirming any right that the interest over this should not. So, against the said order of decree, they preferred an appeal before the Learned Civil Justice Senior Division, which was registered as title appeal number 13 of 2020, with an application for condonation of delay, which was registered as C 15 of 2025. But without considering the proper provision of 65 of the limitation and the other aspects of the case, it has been dismissed. The appeal has been dismissed on the ground of limitation against the order of said appellate authority, as well as the order of Civil Justice Junior Division. The present appeal has been preferred. Next, Madam, Mr. Decca further submitted that though the appeal was not disposed of on merit, and it was basically disposed on the point of limitation. But as by the said order of appellate authority, the decree passed by the Learned Civil Judge Junior Division has been affirmed. The second appeal lies to substantiate the same. Mr. Deca also relied on a decision of Honorable Apex Court reported in 2005, 1 SCC, page 436. It was a Shamsundar Sharma versus Pannalal Jaiswal and others, and emphasized on para 8, 9, and 10 with said judgment. And full stop, and the para 10 of the said judgment read as para 9 for sorry. Para 8 for 8 to Puribo, para 8 and para 10. Considering the entire section made by Learned Counsel for the appellant, as well as appellant, and also considering the substance that I feel it line out of substantial question of law, the 1, 3, and 4 I have marked it. Line to okay, we'll your appeal has been admitted with the some sort of survey.
There's an IA for stay.
This is an application under 41 Rule 5, dated section 151 CC, program of stay of the operation and judgment, and decree dated 4/8/2025, passed by Civil Judge Senior Division, Learned Civil Judge Senior Division, Borkata, means case and so and so. Considering this submission made by sense, and in view of admission of appeal, the operation of so and so be state. This is for the be collected. Second. Okay.
Deeply amended.
This book. Right. It will take a little of Eri Swami all of my book it is a line of kind of detail. 89. 80 oh, no one is applying for the no, can appear some call for the applicant. Please the matter according to target right. Order kan tabel kali kan tabel adjectives aru timing so kam kali more without so here we have received this scan copy.
Well, scan copy receipt, my lord. I have already gone through the same.
Yes.
Lordship, earlier also one bail application was preferred by the petitioner, and this honorable court passed an order dated 5/8/25 at page 23, Lord.
23.
23. Lordship, may kindly be pleased to see page number 25, whereby Lordship had directed the petitioner to appear before the learned court below with an appropriate application for regular bail, which shall be considered by the learned trial court.
It was charged dated.
Yes, then with this order, the petitioner
appeared.
Yeah, he is in jail. He appeared.
When you have surrendered?
Pardon, Lordship.
Oh, he was already on bail. Okay, sorry, jail.
Now also he is in jail.
No, in that occasion also, he was in jail.
He was in jail.
Achha.
Now, in the earlier bail application, as the learned PP submitted, that charge sheet has been submitted.
You
So
were
with this,
directed.
yes, so with this direction, learned lordship was pleased to pass the order. Thereafter, with that order, the petitioner approached the trial court. The trial court rejected the bail application. And that order, lordship, is at page number 26. Now, lordship, the trial court held that there are material in 183 statement. That is the earlier 164 statement. So in my humble submission, lordship, since there was an order of this honorable court, this the learned trial court should not have gone to this aspect in my humble submission, lord. And thereafter also, if we see the 183 statement, lordship, then also it is a now matter of trial. Even the 183 say 164 statement is seen. Now it is a matter of trial, lordship. The petitioner is in jail. This honorable court was pleased to pass an order. With that order, the accused appeared in the trial court. That bail petition was rejected. So this bail application again, lordship. So by now it's almost 91 days. And in the charge is under section 69 BNS. The imprisonment is up to 10 years and fine. So in that case, lordship, now it is a matter of trial. And there is no any bar when it comes to section 69 of the BNS in granting bail.
No any bar means?
Like in some cases, there is some kind of
No,
bar.
obviously, there is no bar.
69, there is nothing. So you will face the trial, lordship. He may be granted bail. That is my humble prayer.
Yes.
Yes, my lord, here, my lord, that is date of arrest is 25/6/2025, my lord. And from date, my lord, it's on today, my lord, 92 days. 92 days. FIR is dated, my lord, 25/6/2025.
Date of FIR itself, he was arrested.
My lord, 25/6/2025, my lord. On that day, my lord, he was arrested, my lord. And my lord, offense that was, my lord, that was a continuing offense for last 6 months. What is stated in the FIR is that. Now, my lord, CS filed on 23/7/2025 under section 318 to 69, 351 3 BNS. Now, my lord, charges frame on 28/8/2025.
2018.
Yes, my lord, 28/8/2025, my lord. And my lord, under section 69 and 351 3 of BNS, my lord. 351 3 of BNS, my lord.
Lordship, I have a humble submission, lordship. In that case, lordship may kindly be pleased to go to page number 38, lordship.
Yes, so charges are already been framed under 69 and 351.
Yes, my lord, 69 and 351, my lord, on 28/8, my lord, and 28th of August, my lord. And my lord, next date was fixed, my lord, that is on, my lord, 11/9/2025, my lord. That record is not with us, my lord. What is the status on 11/9/2025?
Can you tell us whether there any evidence recorded on 11?
No, lordship. On the last date was fixed for evidence, but the informant didn't turn up so far as I know.
That was the first day. There are, my lord, total 6 numbers of witnesses in the search sheet, my lord. 6 numbers of witnesses in the search sheet. Here the case is that, my lord, he is, my lord, concealing his identity, saying something another. My lord, took the victim informant, my lord, secretaries. My lord, after my lord, the love relations, took her to employing some in some job in Chennai, my lord. Thereafter, my lord, she was restrained also. Thereafter, somehow both of them came here, and again when he tried to took her again to Chennai, my lord, that point of time she lost that allegation. There is also, my lord, because my lord now charges frame on 69 and 353. So the rest part I will not come by. Otherwise, some regarding some materials that is on, my lord, electronic photographs and all, making all these things viral, private, some moments. That was also in the allegations. And her, my lord, 180 statement and 183 statement, my lord, that was also there. Medical report is there. Obviously, in the medical report, my lord, that regarding that recent any kind of finding was not there. And as per that, her age is also above that, my lord. So these are the, my lord, materials in hand. Now, my lord, charges frame, my lord, and within the very, there is no case of, my lord, inordinate delay in the part, my lord. Because from the date of, my lord, charge sheet, my lord, already charges frame, my lord. And because it is a, my lord, session tribal case, my lord, the part of committee was also there, my lord. So now, my lord, it is, my lord, pending for, my lord, the evidence, and first it was, my lord, that is as per my lord statement of my learned friend, my lord. That is on that day, my lord, that was the first date for it. That is my submission. I'll leave it to your lords.
Yes, but
Otherwise, my lord, 183, my lord, implication, serious implication. These are the cases.
Lordship, obviously implications are there. Lordship, may kindly be pleased to see page number 40.
40?
Page number 40.
Hmm.
40.
Hmm.
The last three line of the first paragraph. Dr. Sangeeta Das of SDHG Civil Hospital, Morigaon, opined clinically her age is about 35 years. No evidence of recent sexual intercourse at the time of examination. No any visible injury on any private part of the time of examination. In any case, Your Honor, Lordship, now since he is already behind the bar for 92 days. So earlier also there was a order of this honorable court. So considering all these aspects, I humbly pray for bail also. Because now he will face the trial. Obviously, he will furnish his bail bond.
My lord, that part, my lord, regarding my lord, that is the medical report, my lord. Because my lord is a continuing offense. And on the date of my lord, that is the lodging of the FIR, my lord, filing of the FIR. On that point of time, if my lord go through the, my lord, FIR, my lord, that portion is not there. Maybe, my lord, earlier, my lord, that might happen. And my lord, but otherwise, prima facie materials are there, my lord, in this case.
If it is a continuing offense, then medical examination should have corroborated the case of the prosecution. That is not the case, Lordship. That is not the case.
Now see, medical report, what kind of medical report do you want? What's up? Now see, obviously there was a continuing relationship between them. And it reveals that it was a consensual, whatever the relationship was like,
Yes, Lord.
consensual. And that apart 60, she was a major lady and they had their physical relationship. It was consensual. There is no dispute. So recent sexual of intercourse allegations may not be there because recent may not be there. And that apart, their mark for violence will not be also be there.
Yes.
That is quite obvious. That is quite obvious because section itself says it is section 69 only,
Yes.
not the other 64 and all, 69 itself.
Yes.
So obviously medical report may not be there.
In that
is
case,
very
Lordship,
obvious.
that may be
Very obvious also.
that the relationship
Pardon,
was
Mr.
consensual. Lord.
You are Mr.
M. Ahmed, Lordship.
Mr. M. Ahmed, Ilan counsel for the petition. Also had Mr. K. Bosher, Ilan additional PP appearing on behalf of the this is an application under section 20. It is submitted by Mr. Knox. This scan copy of the TCR has already been received. It is submitted by Mr. Ahmed that the accused is in custody since last 92 days and in pursuant to direction of this court, first in BA number BA number BA number 2216 of 2025 dated 5/8/2025, the petitioner moved an application for bail for the learned session just for it. But the said application was rejected by the learned session judge, only observing the materials in the statement made by the victim under section 183 PNS. He further submitted that accused is in custody since last 92 days and hence his further custodial detention may not be required for the purpose of trial and trial. He further submitted that the case has already been charged and charge is already framed against the present petitioner and there cannot be any question of hampering or tampering with the evidences at this. However, petitioner is ready and willing to contest the case by appearing before the learned trial court on each and every date fixed by the Next para, Mr. Bosha, the learned additional PP submitted in this regard that FIR of this case was lodged on 25/06/2025. An accused is in custody since 25/0, no, and accused was also arrested on 25/05/06/2025. And within a statutory period, the charge sheet is also filed and charge is also framed on 28/08/2025. Full stop. The next date was picked for evidence on 11/9/2025. But as per instruction, the evidence could not be recorded in the fixed date. However, there's no any such inordinate delay in the trial of this case to consider his bail application at this. More so, there are sufficient incremental metrics in the statement made by the victim under section 183 PNSS. And considering this aspect also, the petition for bail may not be considered. Petition for bail may not be considered at this. Next para, hearing this submission made by the counsel, I have also been scanned for the vacancy. It's a admitted fact that the victim was a mature girl of 35 years of age, and in the same time, it is also cannot be detected that the accused is in custody since last 92 days, and case has already been charged. Considering all these aspects of the case, without going detail into the merit of the case, considering length of detention already undergone by the accused petition, and also considering the fact that the girl being a major, there may not be any hampering, or girl being a major, there may not be any hampering or tampering with the evidences of the victim. In view of this, I find that further custodial detention may not be required in this case. I find it a big case to extend the privilege of bail. Okay, we're granted bail.
Deeply obliged, Lordship.
My lord, only my lord, one submission, my lord, that may be edit, my lord, because my lord, when he took her, my lord, concealing his identity, my lord, is a different person. My lord. That may be, my lord. He is a married man, my lord, and concealing his identity.
Mr. Woodstock, further Mr. Woodstock further submitted that the victim was taken by the accused petitioner by concealing his identity. So he is a Muslim.
Yes, my lord, he said that man, I am different person, one, my lord, and my lord, he has a
And
later came to know that my
identity
lord.
as a Hindu.
Yeah, he and my lord, name said different, and he is a married person with.
Obliged, Lordship.
Actually, I would give a party role. More order can be done.
May I hear?
Yes.
Steps were taken and respondent number 1 is not available. Respondent number 2 entered appearance. So kindly allow us to take steps again. On respondent number 2.
One has already appeared.
Or sorry, on respondent number 1. 2 has appeared.
Two appeared.
2 appeared.
Well, Mr. Ian.
Ian Das.
Yes. Pardon, Mr. Ian. And I thought for the appellate. From the office note, it reveals that the service on respondent number 1 is still needed. However, the respondent number 2 has already entered into agreement to his counsel, and name of 2 counsels are also reflected in the context. In view of this, the appellant is hereby directed to take fresh steps in the respondent number 1 Registered, you are going to take registered AD only?
Registered area and usual process both.
And list the matter immediately after vacation as a date. Office will be the working days, there will be working days for the office during the vacation also, you can take
Within a week,
within a.
deeply obliged.
May I please, Lordship? So is service complete only in respondent 1 and 6, my lord. Again, we have to take fresh
1
step.
and 6.
Yes, my lord. And we have to take fresh step through paper publication on respondent number 2, 3, 4, and 5.
Why paper publication?
My lord, service is not complete, my lord. I think I could
2,
not see
3,
the.
4 and 5.
I could
Who are
not
they?
see
They are
the records, my lord.
The last order.
In last order, my lord.
In the last order. the
Service is
paper
not
publication.
complete. No, it was one.
their last order was there that they're out
My
of
lord,
station.
in Rajasthan, my lord, there is no Now Bharat Times, my lord. That's why, my lord. We have to again take press step through paper publication. They have taken, my lord, already, but not available. So in
Rajasthan or Borpeta, where
Borpeta, my lord, here, my lord, in vernacular language, Assamese, my lord, in Assamese, and in the item, respond number 3, my lord, Borpeta, in Assamese, my lord, and 4, my lord, in Bengali paper, I think, my lord. He is from West Bengal, my lord.
Indeed. MP.
West Bengal.
two is from Kamalpur, Borpeta.
My lord,
Then
Madhya
two
Pradesh.
is- two
Oh,
is
Hindi
from-
paper, my 4 and 5, Madhya Pradesh and Jodhpur, my lord. Hmm.
4 and 5 are Madhya Pradesh and
And Jodhpur, Rajasthan, my lord.
Jodhpur, Rajasthan.
Only paper publication for 2 to 4. Okay.
Then 2 and 3.
2
They are
and
from
3.
Borpeta.
Yes, my lord. In Assamese newspaper, my lord.
What about 5? 5 there is no order.
4 and 5, my lord. Again, we have to take precision through paper publication in Hindi paper, my lord.
No, but order, the last date, the order was for 2, 3 and 4 only, not 5.
Earlier, my lord, Now Bharat Times, I think they have written Now Bharat Times, I think. my lord.
No, Bharat Times. No.
Now Bharat Times not available in
No,
MP and.
no. On the last order, you were directed through for paper publication for 2, 3 and 4 only.
Yes, my lord.
5, there was no order. That's what I'm saying. You
Oh.
want to take 5 also?
Yes, my lord.
Maybe inadvertently or maybe. Pardon me, I'll show the turning office for the applicant. And also heard Mr. H, your H does. And also heard Mr. Your PD Bhuya?
And ND here.
Huh?
Respondent 1.
Oh, sorry, ND Bhuya. For the respond number 1. As per order dated 21/08/2025, the appellant was asked to serve the notice through paper publication for the respond number 2, 3, and 4. But it is submitted by MS.L. Sharma that the notice on the respond number 5 is also to be taken through paper publication. Rare allowed. However, it is submitted by Ms. Sharma. You have not taken any steps for no one of against this respondent. You have not taken steps for till date. You have
They
not taken steps.
No, my lord.
But submitted that due to inadvertently they could not take steps for respondent number 2, 3, 4, and 5 to paper publication. On perusal of the record, it reveals that respondent number 2 and 3 are the resident of district Borpeta, and respondent number 4 is the resident of Madhya Pradesh, and respondent number 5 is the resident of Jodhpur, Rajasthan. In view of this, The appellant is hereby directed to take steps to paper publication for the through widely circulated SMS daily newspaper for respondent number 2 and 3, and through widely circulated Hindi vernacular language in Madhya Pradesh as well as Rajasthan for the respondent number 4 and 5. After publishing of notice to paper publication, the affidavit will also be furnished to that. List the matter accordingly after publication.
Let's be fixed. That may be fixed.
It can avoid that.
The date to it will be not possible, I think.
Yes, well,
Because they will take steps again, then it will be for
Vacation.
publication, so
vacation start. उनका ले लो लोग दादा.
you take steps
Publish.
as soon as.
Make this your lordship. Lordship, in this matter, the address of the respondent number 2 has changed. Therefore, service was not completed upon respondent number 2. Lordship, one order may be passed to take fresh steps upon respondent number 2 on their new address.
You are for the respondent number 1.
One.
As a whole, how many respondents are there? 2.
2 respondent.
2 respondents.
If the address has changed, my lord, probably they will have to amend the cost title.
That's what I'm also thinking of.
Address changes.
So what is, who is 2 in?
Then they'll,
Who is 2?
yeah,
No, you are for 1.
I'm for one, NF Railway. I'm not for.
You are not going to represent the 2?
I
Why?
cannot, my lord, because the notice has to be served. I'm the standing counsel for the NF Railway, not the Southeastern Railway. So once the notice is served, they will engage us, us only, my lord. But that authority has to be given first.
So what kind of address you want to change? I am just not
Lordship,
following you. Because number 2 is Union of India represented by General Manager Eastern Railway.
The
Kolkata.
address is not.
So
correct,
now
my lord.
what is to be changed? What do you want?
Lordship, earlier address mention is Eastern Railway, Kolkata. And present address is office address, General Manager, General Manager Office 17, Netaji Subhash Road, Eastern Railway, Kolkata 700001.
It was an incomplete address that was given in, along with the
That means
petition.
when you file this appeal, that means that our address was not complete. It is from Kolkata only, the Eastern Railway, that will be represented by the General Manager itself. But the address, it was not proper or specific. That's what. In that case, obviously, he is pointing out we have to change the cost title, also amend the cost title.
You have to amend the.
If you want to incorporate those, the new address, actually new address means this is the Kolkata, you have not provided the specific address. Or they can be office address generally, I just, otherwise it will be again delayed.
If lordship allows, I have no problem, but I'm just indicating that the address has to be corrected. Because if they send the notice on this address, again, my lord will come back because it's incomplete.
So that's why she is now collected the address, the specific address of the office of.
Yes, collected.
That address you can want. You are MS and Hussain?
I am M. Kalita, appearing on behalf of Ms. M. Sharma.
You are MS M. Kalita.
M. Kalita, appearing on behalf of Ms. M. Sharma.
M. Kalita, appearing on behalf of M. Sharma. For the appellant. And also heard Mr. B. Sharma.
Be sure.
The standing counsel and for the respondent number 1. It is submitted by MS Kalita that the address of the respondent number 2 was not specific, and hence the notice return concern. However, it is submitted by her. They have already collected the office address of the respondent number 2, that is the General Manager, Eastern Railway. Accordingly submitted that the notice, the appellant may be allowed to take pasted on the respondent number 2 in the office address of the general manager, district. Kolkata. In view of this, the prayer allowed, the appellant is hereby directed to take precedence on the respondent number 2 in the office address of the general manager district. It takes it within 1 week. Takes
That
it.
address, that proper address probably has to be incorporated in the order sheet, madam. Otherwise, it will be difficult for the registry also. Because by
Okay,
giving
then
by hand,
what you're saying, if she wants to tell the audience?
General Manager Office,
He do-
17.
General manager,
Office, 17.
17.
Yes, Lordship. Netaji Subhas Road,
Netaji Subhas Road,
Eastern Railway,
Eastern Railway,
Kolkata, 700001.
700001.
1.
We incorporate. That's a line to me like it. Okay.
Obligatory.
Give it to this. Give it to Yes.
My lord, I have been instructed today morning only to appear on behalf of the appellant. We have not filed the wakalatnama yet. Over telephone, I have been instructed. So let it come after this puja vacation. We'll be beginning to
Both in 22 and 23 were being
20 and
instructed?
22. Both.
Uh,
In 22,
earlier,
appellant-
was there any other council earlier?
Earlier, TC Khetri has expired.
Earlier TC Khetri was there.
Khetri was there.
And you are for respondent number?
I'm appearing on behalf of Mr. B. Gogoi, Your Lordship.
B. Gogoi.
In 22, she is appearing for the respondents, and 23, probably she is for
She
the
is for the
petition.
petitioner. Dita Milai likho padega. And Mr. P. Mohanto, on the last occasion, he had withdrawn his bakala.
Withdrawn on Silpa. Today morning, I have been informed.
Heard Mr.
Adhar.
Heard Mr. Adhar, the learned council. So in 23, we'll be appearing for the
Respondent.
respondent.
Yes.
And Adhar, he submitted that he got the instructions to appear in both in MFA 63 of the 2024 as well as WPC 1083 of the 2024. And he needs some time to file this on behalf of the petitioner as well as for the response. From the order dated 19/8/2024, it also reveals that the earliest and his counsel, Mr. P. Mohanto, had already withdrawn his wakalatnama from the wakalatnama and the wakalatnama also. Also heard MS. MS?
R.M. Barua, Your Lordship.
R.M. Barua.
On behalf of Mr. B. Gogoi.
R.M. Barua appearing on behalf of Mr. B. Gogoi for the respondent as well as for the petitioner in WPC 1083. Let the matter be accordingly listed after the petition.
Obliged.
And do you have any idea, was there any other respondents here? The only the sole respondent. have not perused the record, that's why I'm just asking.
Probably they are substituted.
Substitute?
Yes.
I to see MFA to do. Only one.
Obliged.
A to the I to the I. I'll go to next.
May I please, Lordship? In this matter, we are going to withdraw our Wakalatnama instead. We'll issue notice to the client also. We need some time.
Notice has already been issued.
No.
No. To your client, or notice, you issued notice or not yet?
Notice. We'll
Not
issue
yet.
notice.
So you are for the respondent.
Respondent 1 to 4.
Respondent number 144. Otherwise, your good name?
M. Hassan on behalf of B. Sharma.
M. Hassan.
On behalf of B.
M.
Sharma.
Hassan appearing on behalf of Mr. B. Sharma.
B. Sharma.
And also heard Mr.
M. Smith.
M. Smith for the response appearing for the response number 1. It is submitted by Mr. Hassan that they wants to withdraw their Wakalatnama from Wakalatnama in NBO office. They sought NBO office. The appellant, the council sought some more time to issue notice to the appellant.
Yes.
Appellant, intimating for their intimation. And they wants to withdraw the Wakalatnama, in that view, they issue notice to the appellant. All that to be right. After puja vacation, it will be listed in between you take steps for issuing notice to your respondent. I mean appellant. Otherwise, you are listing it after puja vacation.
Yes, sir.
In the meantime, you take steps, and if it returns after service and all, then you produce this.
Yes. Always.
May I please, your Lordship?
Yes.
Lordship, this IA has been filed by the claimants respondent for withdrawal of the 50% of the awarded amount deposited by the appellant insurance company before the registry of this court. And the applicant number 1 is the mother of the deceased. Now she is widowed mother of the deceased. The
mother of the deceased.
Mother of the deceased. Father of the deceased expired during the pendency of this appeal.
So,
So my prayer,
yes,
my prayer is that applicant number 1, that is who happens to be the mother of the deceased, may be allowed to withdraw the deposited amount.
50% was deposited.
Yes.
Yes, in that case.
Lordship, we don't have any objection provided they may furnish an indemnity bond, Lordship.
So yeah, this the 50% was deposited in compliance of the order on 27/03/2023.
2023. The order
So
has
there was no order of any
release. There was no order of release. It has been annexed with the application.
Yes, in which way? Order is?
Page 7.
Page 7. We start from page 7. Operative part is 8.
Achha. But no. So you are the appellant.
We are the appellant, Lordship.
Had administrative on the learned counsel for the applicant completely respond and also had Ms. M. for the appellant respondent. The present application has been filed by the claimant respondent number 1, who happens to be the mother of the deceased, being for a direction to the registry for release of 50% of the awarded amount, 50% of the awarded amount, which was deposited by the respondent, the insurance company on 27/3/2023 in pursuant to the order passed in IA Civil 828 of 2023, arising out of MSC appeal number 108 of 2023. It is submitted that during the pendency of this case, the father of the deceased had already expired, and now the petition has been filed only by the mother of the deceased, claiming for release of the amount of now who is two?
Brother of the deceased, is a married.
Uh, mother mother in her paper. Next, but I am cited it also for the respondent of the appellate is which I will see submitted in that indemnity bond may be direction for indemnity bond may be passed. In view of this, the money deposited before the registry in person to order dated 27/3/2023 in IA number ISCV 828 of 2023 be released in favor of the respondent, the applicant of the respondent number 1, Srimati Putuli Nath, the mother of the deceased. And further, the registry is hereby directed to release the amount after due and proper verification of the applicant of the claimant and on furnishing an indemnity bond on furnishing an indemnity bond. With this view, the present I stands disposed. And what is the I about MSc appeal? What is the
In the main appeal,
yes?
May I please, your lordship? In the first part, your lordship perhaps dictated insurance, respondent insurance. It should be appellant insurance. In the first part of the deposited by the respondent insurance, it should be appellant insurance.
Respondent. Okay. Yes, in appeal, what is the condition?
Lordship, we may be allowed to take steps upon respondent number 4 and 5 through prefer publication, Lordship.
4 and 5.
Yes, owner and driver.
I had to dispose clearly. So claimants are the respondent numbers?
1, 2, and 3.
1, 2, 3. Why you want to take it through paper publication?
Because
Was other procedure exhausted?
No, we have taken steps through a registered post. Addressee could not be traced. In respect of respondent number 4.
They are from Assam or
Assam Kamrup, Lordship.
your address was proper there? Post C so and so, resident of so and so of Guwahati. Because 4 is the owner.
Owner, Lordship.
So your appeal is basically on quantum or
No, Lordship. We are challenging fraud in this case.
fraud? So whether it is 4 and 5 are the necessary?
Necessary party, necessary.
So in that case, too, it will be very again difficult. Can you? Now here 2 addresses are there. One is for 4 near Guwahati Airport Gate, Bongra, and is there any byline etc. there?
Your lordship.
Because he is the owner. That's what I'm
Your
saying.
lordship, in the trial, the OP 1 and 2 have appeared and filed written statement through their engaged counsel. Name has been mentioned as advocate for OP 1 and 2.
They 3 and 4 and 5 were OP 1 and 2.
1
there.
and 2, owner and driver.
Oh. Yes, second then, because it seems that paper publication will not help in such a way because
Then we'll take steps to Dusty once.
you can try because 1 is the 4 is the owner.
Yes, Lord.
Let's forget about the 4, 5. He may be driver, he may be address, but 4 is there, so definitely I just wait.
Okay, then we'll take
We can,
steps
we
to
can
Dusty.
allow for Dusty.
Dusty, 4 and 5 Dusty.
When I've heard MS MSec for the application. And also heard Mr. D. Monroe, he done it council appearing for the respond number 1, 2, and 3. It is seen from the, it differs from the office note that the states on the respond number 4 and 5 return answer. In that context, MS
Lordship,
submitted that she may be allowed to take steps to respond number 4 and 5 to Dusty mode. Prayer allowed if applicant will take step to the respond number 4 and 5 to Dusty service. An affidavit will also find that. Yes.
Your Lordship, I am now appearing for 1 and 3 only because
Also,
2 has expired.
So, have you
And legal years of 2 are already on record. So there is no question of substitution.
so name of
His name
can
may be deleted.
May be deleted.
Deleted.
Next prayer for it submitted by Mr. Mondal that at present he is representing the respond number 1 and 3 as the respond number 2 already died during independence of the present. He further submitted that the legal heirs of the respond number 2 is already on record. In that next prayer, in that context, MS the Learned Counsel for the applicant submitted the name of the respond number 2 will be stricken from the post of the member. The raised member. List matter with the as an executive by the raised member.
Oh, place Lordship. May it please your Lordship, I am appearing on behalf of M. Smith. These steps could not be taken, so we need at least 1 week for taking steps. Please kindly.
How many respondents are there?
We are the appellant.
No, you are for the applicant. Respondents, number of respondents. 1, 2, 3 respondents.
3.
Oh, no, sorry, 4 respondents. So you have not taken steps till date.
No.
You are MS?
M. Smith. Appearing.
No, you are appearing for M. Smith. Your good name?
Yes, Lordship. K. Bora, Karshanta.
K. Bora. MS K. Bora appearing there for M. Smith. They just submitted that inadvertently they could not take steps for the respondents. Release of some time. What's it? Apparently, according to the take steps within to the response to registered alien as registered matter for the application as an edit. Okay, it will be listed after application. 1 week you can take steps.
27.
And limitation is but only 82 days, my lord. And
82 days.
Clement side appear, my lord. Delay may condone, my lord.
Do you have any objection?
I already filed, my lord. Lordship.
So what is your ground of delay?
Ground explain in para 4 and 5, my lord.
Para 4
and 5, my lord.
These are due to observation of some official formality.
Yes, my lord.
How many days? 82 days.
82 days.
And your objection is in page?
Yes, page, my lord.
Anyway.
11, my lord. There are 5.
Page. Yeah. Yeah, objection papers. Very objection. Oh, it. Madam S. L. Sharma, Lilanet, this is IA 3132. Ms. L. Sharma, Lilanet, counsel for the not to file. Mr.
HR Ahmed for claimant estimate number 1 man.
H.R. Met. For respondent number?
1.
For the respondent number. This is an application. Section 5 of the limitation for condonation delay of 82 days in filing the connected appeal against challenging the judgment and award dated 4/10/2022 by the city to be in MSC case number 219 of the submitted by Mr. that there's no lectures or negligence on the part of the however 82 days as a whole took to observe the official formalities in obtaining the certificate copy, engaging the counsel, and also in preparing the appeal. Accordingly, submitted expression that delay may be continued and the judgment and the appeal filed against the above referred judgment needed. Next one, and Mr. HR, Mr. Ahmed Learned Counsel for response submitted in his report that there is no proper explanation of delay in the judgment application, and it is not mentioned as to when the certified copy was applied, or there is no mention of the explanation from the period of delay from 4/10/2023 to 21/12/2023. And the delay is also not properly explained as to how it took 82 days time in filing preparing. Accordingly, the petition and submitted that petition may not be considered. May not be considered. Expert hearing the submission in fact and cost have also perused the case record and seeing that the delay is well explained in para number 4 and 5 instant petition, which is found to be quite reasonable and justified. And considering this aspect of the case vis-a-vis the and also for the ends of justice, the delay of 82 days in preparing the delay of 82 days in filing the connected appeal is the effect. Next, the present application is allowed and the registry is accordingly directed to register number connected appeal and register.
So appeal may be listed immediately after variation mallet. I am for the claimant mallet. So appeal may be listed immediately after variation mallet.
Will be come after vacation. Let the register a number, then we come.
Wait, please, Your Lordship. Lordship, I have actually mentioned this matter, Lordship, because on 8/9/2025, Lordship, the actual services were complete. The respondent has not appeared in several occasions, Lordship. And on 8/9, it was decided that the matter will be finally decided on 15/9. Lordship, 15/9, due to paucity of time, the case was not listed. And it was not taken up, Lordship. Lordship, this issue is actually very simple, Lordship. If
No, whatever, but why it is in order column today?
no, today I have bought it by orders for because last on 15th, Lordship, it was not
15th.
taken. It was not taken up, Lordship. So, Lordship,
The
kindly
last order was passed on 8/9.
8/9, Lordship.
But there is no such observation made there.
Uh,
Anyway, it
Lord-
was the matter will be listed. Now, from where you were saying that they are not appearing?
No, the office note, Lordship. They have already appeared, Lordship. I'm praying for disposal of the case,
They have
Lordship.
already appeared.
They have not appeared. The services were complete, Lordship.
Services come.
Yes. Long back, Lordship. Services were complete long back.
Sole respondent is there.
Yes, Lord. Lordship, if I may just point out,
We are not going to hear the matter today.
Lordship, I'll just
because
take
there
5
are
minutes.
some, no, there are the pending work actually by 26, they have to finish it all. the
Lordship,
works.
actually, this matter is covered, Lordship. I have the judgment also, Lordship. That is why, otherwise I will not, I would have not said anything. If Lordship may kindly,
No. You take up. It is not in hearing column also. I don't know why not in hearing column. And there is no such observation is made in 8-9 order of 8-9 also. Simple order is there, that done it. Your name is there, respondent not.
yes, Lordship, but
That much only.
yes, Lordship, but the thing is that the court, learned court below fixed on 15 so that they can dispose it off. Because that time it was at the fag end of the day. That's why the learned court said that let the matter come up on 15, will be disposed of on that day. Because I prayed that it is a similar matter. I will just produce the judgment. It is exactly similar. Facts are the same. Both the parties are also the same.
We don't have time. May not be possible.
Lordship, if 5 minutes, Lordship, nothing.
No, 5 minutes. I have some pending work. It will
Lordship,
be picked up.
Lordship, then I would.
Yes, sir.
Then tomorrow, Lordship.
No, tomorrow, day after tomorrow, it's not at all possible. They are winding up some meetings are also there. It will be immediately, we'll list the matter on 13 itself. It will do 13 then.
Date may not be fixed, Lordship, or after vacation, because I may not be there at that time, Lordship. After vacation, Lord. For admission, then Lordship may fix this
It
matter
will
for
come on
admission.
admission.
After vacation.
The learned counsel for the applicant. From the office note, it reveals that the service is already completed on the sole respondent, but till that the respondent remain unrepresented and the unrepresented. Remain unrepresented or placed in the admission column immediately after vacation as an date will be declared. So you won't be here till from 10:13 to. If no, I'm
Lordship,
just asking why,
10,
because
Lordship,
if it comes.
After Diwali, Lordship. Because this week I will not be there, 13th to 17th.
Then commencing the week from first week of November.
Last week of December,
Last
October.
week of October. On the last week of October.
Highly observed.
May I please, your lordship. My lord, today I am not pressing the, my lord, regular first appeal, my lord. I am pressing the IA only, my lord.
This is an order column, yeah.
Yes, my lord, mention has been made for my listing of the IA, my lord, connected IA. IA, my lord. So already on the last occasion, my lord, this honorable court already admitted the regular first appeal, my lord, and called for the, my lord, trial court records. And my lord, in IA, my lord, which is for stay of the exhibition proceeding, my lord, in that case also, my lord, notice has been issued.
In
My lord, IA. So already, my lord, other side has been appeared, my lord. Now in the trial court, my lord, exhibition has been already proceeded. So we had informed the trial court regarding pending of this case and regarding admission of this regular first appeal. So trial courts directed us to, my lord, produce the, my lord, order copy from this honorable court regarding stay of the execution. So my lord, my prayer is only limited to that, my lord. IA. Since, my lord, already regular first appeal has been admitted, my lord. So kindly that execution proceeding may be stayed, my lord. Otherwise, this regular first appeal will be infractuous, my lord, if that is proceeded.
Title execution has already been instituted.
Yes, my lord, order copy is there, my lord. My lord, in that order copy, my lord, order dated 2/6/25 may kindly be perished, my lord.
You are directed to furnish the certified copy. Yes, Mr. Jain.
My lord, I am representing the respondent. My lord, I'm
they had filed this memo, which is appeal, is incomplete. Because
We have not
they have
memo
enacted documents which are.
My lord, I'll provide my lord.
No, unless this is completed, how I can.
No, my lord, this is regarding only the regular first appeal, memo of appeal.
No,
Now
but-
I'm
but
pressing.
It is
My
a
lord, I'll
part of-
provide the
part
fresh
of
copy,
the
my lord.
appeal.
My
It's
my
a
lord,
part
I'll
of
provide the fresh
appeal,
copy.
And neither they have made pagination nor they marked annexers.
My lord, I'll provide the fresh copy, my lord. My lord, only my concern is the IA. Now the first appeal is already admitted and record has been called for. Now regarding merit of the case, my lord, that will be considered only on receiving of the
See, on the
report.
first day itself, there could have been stay, but stay was not there because of the intention that other side may be heard.
Yes, yes.
So that's why now the other side has appeared. The question is that you have not provided the memo of appeal to the other side. That's why if it is.
No, my lord,
it's
we have
very
already
clear,
provided.
I'm ready to.
We have already provided, my lord. Only thing is that some annexer is not legible. We
Some
have already.
annexures are-
Yes. That is in the
If
plain.
you're ready, then I'm going to hear, otherwise stay.
No, my lord.
My
I am
lord, in the-
handicapped. I could not go through the memo properly.
My lord,
I am handicapped.
well, I may be allowed to submit, my lord. My lord, in the memo of appeal, we have annexed the title suit, which is filed by the my lord, respondent. They are the plaintiff in the main suit. Now I am the defendant. Now, my lord, in this appeal of memo, my lord, I have annexed the title suit, plaint, as well as the, my lord, copy of the judgment and decree, against which this regular first appeal has been filed. Now, this is between the parties, which is, my lord, in the suit. Now, my lord, that regular first appeal is already admitted, my lord. Now, I am, if required, my lord, I will serve the, my lord, fresh copy. That is not a big deal, my lord. But the only thing is, my lord, this IA, on the last occasion, it was only issue notice because this honorable court wants to heard the, my lord, the other side. Now, my lord, my only prayer, my lord, kindly.
Not heard me.
Not hard. That's why I'm saying the notice has
That's
been
why
issued.
this was issued to you,
Yes.
so that you can be heard.
Yes. Now, my lord, in IA, my lord, nothing has been annexed. Only this is an application since regular first appeal has been filed. Any proceeding, my lord, which is pending before the trial court, that has to be stayed. It is under order 41 rule 5, my lord. So my prayer, my lord, it is prima facie, my lord, from the record which I have produced before this court. Already it shows that, my lord, trial court, my lord, this execution proceeding is proceeded. My lord, if it is proceeded, my lord, then this matter will be infructuous. My lord, the next date is fixed on tomorrow. Now, my lord, the issue is regarding, my lord, the suit was filed for specific performance of contract. Now, the my lord, learned, my lord, the plaintiff, my lord, they filed this suit on the basis of agreement for sale for a particular property, my lord, and that property was sold by two brothers.
So
But
what was the decree?
my lord, decree is, my lord, now the whole property is owned by three persons, two brothers and one sister, my lord. That agreement was executed by the two brothers, not by the sister. So court has observed, decree partly saying that, my lord, leaving the part of the sister, my lord, this two brothers share has to be, my lord, decreed. Now this is an undivided property, my lord.
Okay, then we are not on the merit of the case. Yes,
That's why,
Mr.
my lord, my
Judge,
only prayer is, my lord.
otherwise also one thing that if suppose your execution is further proceeded and suppose decree is somehow executed, then definitely the filing
Nothing
of
remains,
the
my lord, in this
RFS,
appeal.
will be instructured. In that context, if you want to submit anything
My lord, then my lord.
or till next date,
Yes.
that
My lord,
can
my
be-
lord, my lord,
that
my lord.
can be.
Because tomorrow is the date, my lord.
That's what I'm saying.
My lord, my lord.
Till the next step,
Yes, till
then
the
the
next step.
matter is listed.
I'll serve the fresh copy, my
You
lord.
serve the fresh
Yes, yes,
copy
my lord,
with the
definitely.
all annexures
My
and
lord, my
also
lord.
that he can Mr. K. Singha, the learned counsel for the applicant, and also for the architect, the learned for the respondent for one. This is an application under order 41 with 5 David section. Mostly of the execution of the improved judgment decree dated 30/09/2024 casting is number 12 of the 12 by 12 to 2012 and its civil judge senior division rubrics. It is submitted by Mr. Singh that the title execution number 02 of the 2025 has already been proceeded for execution of the decree passed in the title suit number 12 of 2012 and by its order dated 2/6/2025. The JD of the present appellate was also directed to furnish certified copy of the stay order. If If further submitted that if the decree is executed during the penalty of the first appeal, which has already been performed, the purpose of filing the appeal will become enhanced. The date for stay of the execution of the decree dated so and so will dispose of connected. Next product. Mr. Jain did not counsel appealing for the response submitted in this report that he is not in a position to submit anything else. The appeal memo, which has been furnished to the copy of the appeal memo, which was furnished to him, is incomplete, and the annexures filed along with the appeal memo is not legible one. Then the according date none, not legible. In view of this, the appellant is hereby directed to furnish a fresh copy of the memo of appeal
Along with annex.
along with all the with annexures and to legible annexures to the debt. However, considering submission made and considering both sides, and also considering the fact that the title execution number 02 of the 2025 has already been proceeded, the execution of the decree dated 30/09/2024, passed in case 12 of 2012, is hereby state till next day. List the matter accordingly after Puja vacation. And what is the appeal in appeal? What is this?
Already admitted, my lord.
LCR is not-
Trial court,
LCR is
LCR
not-
has been called for, my lord.
LCR is not met.
Appeal to so and so for you. Appeal is already admitted, but from the office to the PCR is not yet seen. Issue reminder, registrable to the network.
Obliged.
I have to dispose knife on it. Knife.
Wait, please, Your Lordship, my lord, I appear for the respondents. We have filed our counter affidavit. Lord, I pray that the matter may be, if in the event this matter gets directed to be listed for admission hearing, an observation from this honorable court that fraud must first be decided upon, my preliminary objection, because the honorable Supreme Court order doesn't find place in which had finally put at rest the list between the parties. Well, that does not find place in their application dated 19/10/2015 for a re-execution of a matter which has already been decided and put to rest by the Honorable Supreme Court. Well, that appears at their application appears at page 83. The prayer appears at page 83. The fraud angle must first be decided by this Honorable Court. Then, I'll argue on merits. That's the observation I pray for. And for exemplary costs in the event it is to be held by this honorable court as fraud.
Lordship, in this case, we need 4 weeks time to file our affidavit in reply.
No objection, my lord. Only thing, that observation that fraud must first be decided upon by the Honorable.
So from 83, page 83, what do you want to submit here? 83, you are pointing out.
Page 83, my lord, page 83 is their prayer. Yes, my lord, the petition, the petition before the learned court below, upon which the order impugned came to be passed by the learned executing court. My lord, that does not mention. It starts at page, annexure 11 starts at page 78. Extends to page 84 of your lordship's brief. My lord, that does not mention the order of the Honorable Apex Court. That must first be decided by this Honorable Court. Upon this application, the order impugned came to be
Anyway,
passed.
you want to submit on some preliminary issues.
Yes, my lord, the fraud angle. I have raised that in my counter affidavit.
You are MS?
S. Agarwal.
S?
Agarwal.
S. Agarwal. S. Agarwal.
Yes, sir.
And for the petitioner, also had MS and Sharma, the learned counsel for the response. It is submitted by Ms. Sharma that they have already filed their affidavit in opposition, to which MS Agarwal submitted that they need at least 4 weeks time to file their affidavit. However, further, it is submitted by MS Sharma that before hearing on the merit of the interpretation, she prayed for an hearing on the issue on preliminary issue, especially on the prayer anthem, which has not been which has not been brought by the respondent in their case. List the matter accordingly in the admission column.
Yes,
Or it will be-
sometime in the 3rd week of November, subject to the convenience of the sound report.
What do you say?
Lordship. Last week of.
No, my lord, I have objection, my lord. I'll be away. I will be out of the country, my lord, visiting my daughter.
20 November.
Lordship.
Deeply
28th
obliged.
of November.
Obliged.
By that time, you have filed your affidavit in reply. And before going to hear this one, we may hear the matter on this angle.
Deeply.
Obliged.
So petitioner side is not there. Additional senior government advocate আছে তেখেতক অহা নাই নি খবৰ দিছে নি? থাকিব লাগিছিলে government advocate. You are representing 1 to 7. All.
Otherwise, we have no objection if the prayer of the petitioner allow before this honorable court. We have no objection. Lordship.
The question is they are not present today. None appears on call for the state of Assam. Hard MS.
A Begum.
A Begum.
A Begum.
A Begum appearing for the response. We are not going to mention your submission today itself. Let them submit, and then if you don't have any objection, it will be allowed accordingly. But as they are not present today, it will be after vacation, okay?
Any date may be fixed, Lord.
You want any date? Date, if in that case, the date will be may not be in the month of October, Paris and any. At best 31st of October, not prior to that. Now, she submitted that you have appeared for the respondents and you don't have any objection, but the other side, the senior government advocate, they're absent today. So we are fixing it on 31st of October. For this time, if you don't have any objection, matter may be disposed of. Let him submit.
Lordship, we have filed our counter reply affidavit.
You have filed your reply.
Yes, Lordship.
What is the IA for?
I is an application under order 39 rule 1 and 2, Lordship. They have served as a copy, Lordship, of written objection, but as per the office note dated 22nd September, no affidavit in reply has been filed. Perhaps it may not be taken with the record.
No, you are going to file.
No, I have filed, Lordship, counter reply. Most
even-
it has come to the record or may not be, Lordship. But I have already filed it, Lordship, and copy has been given to them, Lord.
Copy has been served upon us, Lordship.
Oh, I mean, in RSA, you are for the respondent.
Yes, Lordship.
And who, if I,
IA 1136, Lordship.
1136.
The appellant side has filed the application, Lordship, injunction application.
We have filed.
We have filed already.
So they have already filed their affidavit in petition.
Opposition, a copy has been also served upon us, but the same may not be, perhaps is not taken with the
It may be
record.
directed to brought on record, Lord.
As per order, office note dated 22nd September, Lordship, no affidavit in opposition has been filed, is showing like that.
When you have filed this, your objection? Because
We have filed it 2 days back, Lordship.
Pardon?
2 days back.
2
On
days
Monday.
back.
Last
But
Monday.
here their office note is of 22nd of September, wherein it is stated no objection is received by the section. It is
Maybe
not
after
also
coming off the bench, then in the 22nd we have filed, maybe there, Lordship.
Achha.
That
Monday
the
is
record
20,
coming to
Monday
the
is
bench,
22nd
then
only.
might have. That may
Then
be
we'll
brought on
list it
record,
after
Lordship, and order
vacation
will pass.
only. It will be,
Yes.
a pass order will be
Yes,
passed
Lordship,
accordingly.
my humble submission, Lordship, my interim prayer may be considered till then, Lordship.
Not
Can
at
it
all,
be
Lordship,
considered?
not at all.
How can it be considered? On the first day of hearing, it could have been a prayer for their interim report. Other side has already appeared, so at this stage though, we cannot pass any matter on interim. It will be heard according.
Kindly, that may be fixed, Lordship.
You will
Immediately
sit-
after vacation, Lordship, if possible.
And applicant heard, you are Mr.
UB Sharma.
U.B. Sharma. Achha. U.B. Sharma for the applicant appellant. And also heard Mr. S.K. Pudler for the respondent. It is submitted to Mr. Pudler that they have already filed their object in opposition. But that has not been tagged along with this record. And the as per the office note 22/09/2025, the concerned section has not received the affidavit in opposition. However, it is submitted by Mr. Porter that has already been filed on 22nd September itself. The registry is hereby directed to tag the affidavit in reply filed by the respondent on or before the next date of listing. List the matter. You want a fixed date here?
Yes, Lordship.
At best, 29th of October. Prior to date, we don't have. 29th of October will do.
Kindly some other date, Lordship. Monday.
31st, I will not be. 31st, 30 maybe, Lordship, if not, otherwise 28 or 30 even, Lordship. 31st and 1, I will not be there, Lordship.
Can it be on first week of November, Lordship? That maybe.
In that case, we have to go because 30 also we have already listed 7 to 10 numbers of hearing matters.
Maybe 311, 411, 611, Lordship, no problem.
That can be 611 best.
611.
And what is the stage of this RSA? We have
RSA is already been admitted, Lordship.
already admitted.
Admitted.
We have received the
perhaps
LCR here.
Lordship.
LCR has already been received or not yet?
TCR has been received as per this.
TCR received.
TCR has already been received, Lordship.
TCR already. Okay. We hear the matter on IA first, then we'll go to that.
Lordship.
Highly appreciated.
Obliged.
May I please, my lord?
33 along with 41. Oh, supplementary.
My lord,
Yes.
on the last occasion, my lord, service report with regard to respondent number 41A and 41B was awaited, my lord.
My lord, I can represent them, my lord. I have taken instruction, my lord.
41A, 41B, you can represent. You can represent.
I can represent
Okay.
since they are family members, my lord. I have taken instruction, my lord.
Now then, what about the 5?
235 already I am
Already, my
representing.
lord, service, my lord, what happened, my lord, during this respondent number 4 died, my lord.
Huh.
So
They
the,
are the
they are the legal.
Legal.
So, my lord, this IA, my lord, lordship may take up IA number 1453, my lord.
This
My
is
lord,
for
this-
what?
My lord, this is for
Delay condonation, my lord.
delay condonation, my lord. What happened? He dies long back. But this appellant, we do not have any information, my lord. Only when they appeared, they have informed about their death, my lord. Then these applications were filed, my lord.
There is delay of 4,000 something, my lord. I will file objection, my lord.
Because delays of 4,087 days.
Yes,
Because we do not know.
Quite a long.
Quite a long delay, my lord.
Yeah, my lord, even in para 4, para 5 of their affidavit, my lord, delay condonation, my lord, they have mentioned that we have informed on 26/4/2024 also. That is the last year, my lord. Even that date, if we consider their
Money,
then
if
they
it
also
is considered the date of knowledge.
that's it.
In that case also it is.
Yeah, it will be delayed.
Let them file their objection, my lord. I will deliver.
Otherwise, service is completed.
Completed.
Since he appeared, my lord.
I can represent my lord. 4-1.
And what is 41?
Lord, 41, my lord, I have filed one IA for a stay, my lord. What happened? Appeal is already admitted, my lord. They have filed one execution proceeding, my lord. And in that.
Now the question is that we have to
Yes, my lord, for the
delay
delay
reconvene
has
first
to be
and only.
completed.
That is in the substitution, my lord. A main appeal is already admitted. And records are called for, records are here.
Okay, now let's come for the IA civil 14531. Part Mr. A.K. Gupta, the learned counsel for the applicant, also heard. Mr.
Mala S. Hazarika.
S. Hazarika, appealing for the respondent number 3 and 5. He submitted that he can also represent the newly implemented respondent number 41A and 41B, as they belong to the same. Thus, the services seems to be completed here in this case. However, it is submitted by Mr. Hazarika that they will file their written objection, as the delay is a long, against the long period of delay, that is 4,087 days. In view of this, let the matter be listed after vacation will do.
Well, after vacation.
If the matter be listed after vacation, then it will be fixed by the registry. In the meantime, the respondent will file their objection. Now, again, what is 41 you're saying? It is just stay.
My lord, this is, I have prayed for a stay of the, my lord, judgment as well as, my lord, execution case, my lord. 1535. Is not a copy.
Unless here also we have not received copy, we will file our objection here in this.
As per your instruction, is there any execution?
Yes, my lord, I have given the execution case number also, my lord, title execution number 5/2021. That is going on, my lord.
File a petition, because obviously without, if they want to submit any hearing,
Let them
because
file
they
their
have already
objection.
appeared. Otherwise, if an ex parte order was there or before their appearance, that could have been, but otherwise they have already appeared. Same order for it's objection paper. Let the matter be listed immediately after vacation.
May I pray for a date only?
In that case too, you have to go for November only, because we have fixed it after Puja vacation, because 20 benches are there.
Yes, madam.
So it may be adjusted. When if you pray for date, then it will go in the month of November.
Let it be first week of November, my lord,
First week of
otherwise it will
November
not be
only.
listed, my lord.
Okay,
That will
then.
be-
3, 4, 5,
Copy-
6.
I will serve it.
My copy is not served.
I will
Oh,
serve
oh,
it.
in IA 155, 155 Rakota Lipa, the applicant is also hereby direct serve a copy of the petition within the course of today. Also, today only you can
I will give to them.
get a party. He's saying this 7th of
7/11.
7th of.
Obliged.
Obliged.
My lord, delay of only 37 days, my lord.
Sir, don't have any objection, lordship?
You don't have any
Don't have
objection.
any objection. Claimant
IA
responded.
IA civil 1600. Same for official formalities. Part Davis Elshan is an counsel the applicant. This is an application under section 5 of the Limitation Act for condemnation of delay of 37 days in preparing the appeal against the judgment and award. It is 16/12/2024. Passed by learned member in the city, Diphudor in MSC case number 56 of the 2008. Next, right, submitted by MS El Sharma, that where you have explained your delay, in which para?
Para 3, 4, and 5, my lord.
That they have explained their delay in para 3, 4, and 5, where there was delay was basically delay, wherein it has been explained that delay was basically for observing some official formalities before preparing the connected app. Post. And may Mr. Agarwal, the learned counsel for the respondent, raise no objection. Submitted that he has no objection if delay is confirmed and the connected. Consider next, considering this submission, will file learned counsel also consider the delay as a delay explained it is justified and reasonable. The comma, the delay of reasonable comma, the delay of 37 days in preferring the connected appeal is hereby undo. Petition is accordingly allowed. Registry is directed. Okay, it is allowed, registry will be directed.
May the appeal, my name may kindly be shown, as a claimant is shown. Without a order, then.
This further, considering this submission made by Mr. Agarwal, the registry is also hereby directed to reflect the name of Mr. Agarwal as a respondent after registering and numbering the
May I plead the lordship? Lordship, in this IA, I have prayed for withdrawal of the deposited amount.
Yes, Mr. Sakya, you have.
Lordship, in this case, there is no loss of dependency. Actually, victim was a government servant and he is getting, family is getting compensatory family pension, Lordship. So, but
He
medical.
was a government, Assam government.
Assam government that is scheme, Lordship. So, medical expenses is stated to be about 15 lakh prior to his death, treatment. Victim.
No money, it is only the medical expenses.
The medical expense that he had incurred, family had incurred during treatment of the victim, it was stated to be about 15 lakh 70,000.
More than 15 lakhs.
We have filed of this file appeal on that one also, that medical expense that is awarded is also on the higher side. But if that is considered and is
So now you have deposited the percent of the entire
50%.
awarded amount, or what?
company has deposited also 50% of the awarded amount along with interest also, Lordship. So it comes to, Lordship, 46,000 something.
46 lakhs.
46 lakhs, 37,000. But at this stage, Lordship, about 30 lakhs may be released, but subject to bond. If we win the case, ultimately they will return that.
How many lakhs? 30.
30. 50 lakhs,
30 lakhs.
30. Medical expense about 15 lakhs. And they are
I'm
at
following you. On one hand, you are saying that obviously there is a government scheme.
Yes.
So dependency factor will may not come.
Yes.
I don't
yes,
know.
Yes,
It may
yes,
come also. I have not gone through.
Yes.
But the obviously the medical part and other expenses will be
Yes,
there.
yes.
So now you have filed the 50% already. Now you're insisting that 30% may be released. I mean, 30 lakhs may be released.
About 30. 46 lakhs we have deposited first.
30 lakhs may be released.
With one loss.
No,
That
no,
they
obviously,
will-
bond will be the yes in that context.
Your Lordship, if my learned friend is insisting on that, so my only prayer is that 30 lakh may be released. The rest of the amount that has been deposited may be refunded to the insurance company.
Refunded.
Refunded, or your Lordship, it may be kept in the fixed deposit account in the name of Registrar General.
That may also be done, Lordship. If
Otherwise,
we will get
that on that amount, I will not be entitled to interest, because this case will almost take 7-8 years for disposal. So 10 lakh, 16 lakhs odd will carry so much of interest. But since the amount is deposited, I will not be entitled to any interest. In some cases, it has been ordered that the amount may be kept,
Then may be refunded.
or it may be refunded. That would be more easier.
that
Otherwise, the
can-
registry will be in more trouble.
And registry may also keep it in fixed deposit. And if they win, they will get. If we win, we will get that amount. Will be-
Better to refund, I think. Then you do yourself. What is the case? So
Like
in that case, we are releasing 30 lakhs out
Will-
of 46 lakhs something.
Yes,
Whatever.
Which have won.
Indemnity bond.
So
Lordship,
can
it
you
is-
tell us the exact amount? 46 lakhs?
46 lakh, 37,066.
87,000.
46 lakhs, 37,000.
37,000.
66 rupees.
66.
It is not the 50%, your Lordship. They have deposited more than 50%.
With interest loss. If the company software is something like that, it counts like this, Lordship.
It is more than 50%.
More than 50%.
Yes. With interest.
Otherwise, as a whole, your award was
Award was
76 lakhs.
76, 70.
76.
50% comes to 38 lakhs.
38 lakhs.
Obvious. Pardon, Mr. Demo, of the Learned Counsel for the. You are for the respondent, I think. right?
Yes,
And the
respondent.
applicant
Yes.
respondent.
Respondent number 1, 2, and 3.
And 120, the claimants.
Claimants.
Respond. And also heard Mr. A.J. Sekar, the Learned Counsel for the applicant. This is an application seeking the deduction from the court to release of the 50% the awarded amount, which has already been deposited by the apparent applicant insurance company in person to order dated 25/07/2025 in ISC 2060 of 2025, arising out of MSC appeal number 270 of is submitted by Mr. Mondal that at the time of seeing the order, there was no order of release by the present petition. The claimant respondent had agreed for the release of the same. So here you want to release in the how many claimants are there in fact?
Initially, there are 4 claimants.
Ah.
Subsequently, mother of the deceased also expire in this case. Now, wife of the deceased and 2 minor daughters.
Wife is number 1 and 2 and 3.
Applicants are the wife and
2 daughters.
2 daughters of the deceased.
Applicant. এখানে তো আছে। And hence this petition and hence this present petition has been filed by the claimant's respondents for release of proceed. Next, Mr. Soika, the learned counsel for the appellate submitted in this reason that we have challenged the quantum of the award and the deceased being a government employee, the respondents are getting the pension, no, getting the this that is salary, salary of the deceased post. However, Mr. Second submitted that they have already deposited 46,37,066. That is the 50% of the awarded amount, including the interest. And he has no objection if 30 lakhs is released in the name of the claimant respondents.
Your Lordship, 1, 2, and 3.
Claimant respondents number 1, 2, and 3. Subject to furnishing an indemnity. Next para, Mr. Mondal submitted if 30 lakh is released in favor of the claimant respondents, then remaining amount of money may be refunded back to the company. Otherwise they may will lose the interest portion. In view of above, the registry hereby directed to release rupees 30 lakhs in favor of the claimant respondent number 1, 2, and 3, subject to furnishing an indemnity bond, due and proper verification. Further, registry is also hereby directed to refund the remaining amount of deposited amount, that is 16 lakhs 37,000, 16 lakhs 37,066 to the insurance company of the account with observing all the properties. With the observation, the present highest.
May I please, Your Lordship? At 5 lakhs may be directed to be kept in fixed deposit account in name of the
Earlier it
minor
was
debtor.
the order.
earlier order, but in that will be in terms of ratio. So if it is specific 5 lakhs, then it will be more easier.
5 lakhs for 2 minors.
5 lakh each. 10 lakhs will be
5 lakh each means this wife is a major woman, I think. But
yes.
still
Rest
you
of the
want
amount.
that 5 lakhs.
No. 2 minor daughter, 5 lakh 5. And
No,
rest
that's-
of the amount may be released to the
So that will do by the registry only.
registry only.
Further, from the release amount of rupees 30 lakhs, it is further directed to the registry that rupees 5 lakhs each to be deposited in a fixed deposit in any nationalized bank in the name of respondent claimants number 2 and 3. That is 2 and 3 who are the minor daughters of
Till majority.
of the claimant respondent number 1 till they attest him. The rest of the amount may be released in favor of the respondent claimant number. Respondent claimant of the wife. Milai দিব that one.
Highly obliged.
Let's say petitioner claimant has filed
Yes, 36.
say the claimant petitioner has filed an application for allowing to withdraw the deposited amount in his favor. But there is an order from the tribunal regarding making fixed deposit and shared the parents, mom, husband and the brother. So let's say they want modification of the order. Tribunal has or directed, so we'll take the instruction to the company regarding this application. Because in tribunal's order, let's say we'll find in the appeal memo,
Appeal to. Appeal to. It's an appeal memo, page number
page 13,
13.
page 13. 13.
Yes.
Close it for
Mm.
para 36.
Mm.
1,21,000 shall be released into the claimant number 1, mother of the deceased, to meet the immediate expenditure. 22,000 is related to the claimant number 2, father of the deceased. 7,50,000 shall be released into the claimant number 3, brother of the deceased. And remaining amount will be made fixed deposit. 130 FDR of rupees 10,000 each in the name in the nationalized bank for a period to 1 to 130 months. So already there is an order to release 50% in the claimant, but tribunal order is not modified, so it cannot be Lordship. And to protect the interest of the claimant, this has been done because otherwise Lordship is aware the money has been withdrawn by someone. That is why it is been protected by the tribunal. So I'll take the instruction for the company regarding Lordship these things. And secondly,
So
Lordship,
as per the order, there was already an order of 130 FDRs.
I have no objection if 2 lakhs is released in favor of the claimant because interest will be they will get the interest. 2 lakhs is released at this stage in favor of the claimant. I have no objection to that effect, but not 50%. Because already tribunal's order is there and Supreme Court has categorically stated and this court has already stated that when there is a violation of policy condition, insurance company cannot be directed to pay the amount because the power under section 142 is on the Supreme Court, not on the tribunal or not the High Court. Already tribunal has held that the owner is liable. Doctor will kindly see.
Owner is liable,
Page-
then pay
page-
recovery order was there.
Lordship. Owner is liable to pay compensation. Page 12. So pay and recovery order has been given by the tribunal, that cannot be. But considering the claimant position, Lordship, claimant is a mother of the deceased, and there is another MST case. 2 MST cases has been filed. 2 motorcycle made an accident, head-on collision. 2 claimants has filed 2 different cases at Guwahati as well as at Jorhat. Accident took place at Jorhat. In one case, there is a stay order from this honorable court. That is why this case was not proceeded. Thereafter, tribunal has passed this judgment. I do not take any instruction regarding the earlier case filed by the claimant at Johar. So I'll take the instruction. Lordship, fix this matter after vacation.
Okay, no problem.
It will be fixed after vacation.
Otherwise, you have deposited the 50% of the.
Yes, Lordship. So here only I am the claimant, Lordship. Mother is the deceased, Lordship. And I am submit the father, and my another son is not given any money. It was simply that confessor head has been given.
They are not dependent. That is why Supreme Court has categorically stated they are not entitled.
That's why there are some categories, the under order
Yes,
part.
yes. So I have,
7,000 some
I have given only the awarded amount. But the main position is this: I am a major, mother of the deceased,
Yes.
and 130 numbers of fixed deposits. It is practically of 10,000 each. It is not practically feasible. We went to the bank. They have told that if 2-3 FDRs
Lordship is
there,
aware what is going on in MSD. That is
no,
why
that is different.
that is why Lordship it is well protected.
So I requested my lawyer friend that 5 lakhs is paid to the mother and remaining amount may kindly fix the deposit.
Let him take the instruction whether FDRs
Yes.
are there or not.
Yes.
And if there is not, definitely I can understand being a
Yes.
mother, most probably she
Already
may
withdrawal-
be in the need of money.
Yes, already withdrawal order is there, Lordship.
Withdrawal order is also there.
Is there.
Withdrawal order is there, but tribunal's order has not been modified regarding making of fixed deposit.
If withdrawal order was there, now subsequently you have filed this one again.
Yes, Lordship.
Why? What need? Why you have filed this one? If withdrawal is
This,
already there.
this 130 numbers of fixed deposits of 10,000. And that amount given to the 2,000 conventional heads to the father and my another son, that is also telling with the order.
Lordship will take this matter after vacation. Lordship.
Tally with the order. What?
Yes, Lordship.
And there are specific some categories are there by the learned tribunal.
Yes.
That these things will be there, 22,000 to the father and 7,000 something to the brother. And there's the mother, definitely.
Yes.
But however, for the protection or whatever, rightly submitted. So 130 FDs are there. Practically may not be a bit difficult for 130 numbers of FD.
Yes, yes.
But let us see if they take instructions.
And there is a direction to release the amount on maturity to the claimant number 1.
Let it
So
be
court,
Lordship
every
understand?
aspect is considered by the court.
Yes.
Sometimes 25% to not getting by the claimant. Sometimes it happens. Some get
Yes, there are. Should not be. In fact, sometimes it happens. A mother loses her son, and we came to know subsequently that these things are happening at the some even 25%. If 75% is misused or some, it's a really matter of concern.
very sad.
That's why I will requested my lawyer friend to give 5 lakhs to the mother and remain amount fixed deposit.
He will take it. Mr. Pierre, applicant, non-applicant, and also heard Mr. S.K. Goswami, done it for appellant. However, it is submitted by Mr. Goswami that he needs some more time to take proper instruction to become. That was in view of this, let the matter be listed immediately after vacation as a date. We are not going to fix any date because date will again create some problem.
Obliged.
Well, that now,
Please, Lordship.
submit copy of substitution.
My lord, the condonation application, Lordship, first setting aside abatement, Lordship, and substitution.
You need some time.
My
Or-
lord,
Notice
yes,
may-
I have to take instruction and moreover, my lord, respondent also died. Way back, I think in the year 2018 something, I have missed my file. So I inform him, so both are living together adjacent to each
No, no,
other, just opposite road.
That is different, Lordship. One is a,
And the respondent is the sister of appellant.
no, no.
Till now substitution hasn't been made.
Lordship. Anyway, Lordship, it
That
is
is
not
surprising.
informed, Lordship.
That is surprising.
Lordship.
So what was the, delay in filing this substitution? What was the number of days delay?
Sorry, Lordship.
Delay was how many days? Or years?
My lord, it is,
Because
two
as Ms. Devi has submitted that it is
200.
brother and sister matter is between.
my lord, more than 200, 500, Lordship.
500.
It is still in the year 2023.
Lordship.
So I have to take instruction and it is also
You have
delayed
received the
also.
copy today.
And respondent also died. He may suffer.
In that event,
So
my
if
lord,
any other respondent died, then you have to make a,
sorry, Lordship.
no, this is for which respondent? Respondent number? For
Sole
substitution?
respondent.
Sole respondent.
One respondent is the other, the
Performer,
respondents are also there.
I don't know, more performer. whether
One
they
to,
appeared or
2
not.
to 9 are also there, Lordship.
They are pro forma.
Yes, Lordship.
Now, whether they appeared or not, I think they have not appeared. Performer.
845 days delay, Lordship.
840.
And yeah,
So for the respondent number 1 or the sole respondent?
yes, only with respect to the respondent number 1.
Main respondent.
Yes.
So I have to take instruction regarding.
I don't know, Lordship, this application with respect to the appellant, Lordship. Appellant died, Lordship.
Oh, appellant died?
Yes,
Lordship.
yes. Appellant died and respondent also died.
So you take the instructions of the other side also. The respondent also died.
Then, my
In
lord,
that
I have to
case-
file a separate
Separate, one
application,
separate,
Lordship, with
another
date of
petition.
my lord, death is required, Lordship. Let the,
Obviously, take the information.
yes, Lord.
And then you file.
Now, both are brother and sister.
Rule 10, Lordship.
Which are both died.
Even my lord, the applicants, my lord, did not
Now,
know
who
whether
will
appeal was
enjoy
filed.
the fruit of the decree? Who will pass their bill there?
Lordship. In that event, after my lord,
In fact, in most of the
substitution,
RSA,
it will
one
be better.
generation already died. And then
So as per law, he has to substitute.
anyway, okay then.
Only in this case, my notice may be issued, Lordship. Other respondents are also there, Lordship.
Now, the thing is this, whether the private performer respondents appeared or not. If they are not,
Not appeared, Lordship.
decide what it is.
Not appeared, Lordship. 1 to 9. Sorry, 2 to 9.
2 to 9.
If he deserved, then notice may go.
My 2 to 9, my lord, they are not interested. Then in that view, Lordship,
No, I cannot say whether that's what she is asking, whether in the main appeal they have already appeared or not yet appeared.
yes, Lord.
Notice for them, notice already issued or not yet issued.
In that, my lord, in appeal, Lordship, it was issued, Lordship.
It was
Notice was
issued.
served, Lordship.
Those were served. So you
Yes.
want to submit here also? Issue notice?
My lord, in
You
this
can,
case,
if
my
you
lord,
want,
lord,
then,
trend
because
is
they are made parties. If you
their
want,
party,
then-
Lordship. Has
I am not
proposed.
concerned with performer respondents.
Yes, yes.
If they are not interested, Lordship,
No, I cannot say that.
appeal is against ex party, Lordship, in the necessary, Lordship.
No, whatever they are performer, they may not be interested. I'm not on that. But question is that if you made the party, if you want, then definitely notice has to go because they are
Yes.
party here.
Yes,
Otherwise.
yes,
And in the meantime, she may also file her objection.
yes,
Which
yes.
is there.
If your Lordship thinks, my lord, the notice may be.
It means in a sense you have made party na.
Yes,
If
Lord.
parties were not there, then matter would have been different. But you are they are the party.
In the appeal, my lord, after receiving notice, my lord, they have not appeared, Lordship.
Part Mr. M.H. You are Mr.
Amit.
M.H. Amit.
M.H.
Responsible for the
Sole respondent also died.
applicant appellant and also had MSB David in the net counsel for the respondent. It is submitted by Mr. MSDB that he needs some time to file her objection. And they have she received the copy, the memo, the copy of the petition today. But it is seen that there are 2 to 9, the other respondents are there. So applicant is also hereby directed to issue notice to the other respondents. To register the Please the matter accordingly after. Now, here in the instant case, I cannot say the appeal. In appeal, I may give you a direction for this, take the all information from the respondent. But remind you, if I record these things, then definitely it will be your knowledge, will be count. So that is there also.
Lordship.
So should
My lord,
I reflect or not, should not? Because now my question is that if suppose I'm reflecting in the order itself,
Lordship.
that the information is there or not, then your knowledge will be count from this day only. So
My
it's
lord,
up to you,
my lord,
or
the date-
otherwise she can file a petition
My lord,
giving
date
all
of-
the details.
Yes. Date of death, my lord, is required to be, my lord,
Inform.
submitted as per rule 10A.
Obviously.
Otherwise, I cannot file.
Otherwise, you can file one petition.
Yes.
Then knowledge will be counted on that day itself, or otherwise you can take the
Lordship.
other instructions also. So you are not passing.
They can also enquire because both
No,
are
no,
living
my lord.
together, just opposite the road.
No, Lordship. My lord,
Brother and sister,
my lord,
own brother.
my lord, I have no communication, Lordship.
You should first inquire.
That, my lord, this is very crucial, my lord. Otherwise, they knows, my lord, they know, my lord, the applicants may have no knowledge of the
No,
exact.
just I'm asking in that case whether I should reflect in the order. If I reflect in the order, then it will be count for your knowledge.
My lord, today I have knowledge, my lord, but that is not in my knowledge, Lordship. On the next
Then
date,
you
my
have
lord,
to
I
take,
will
you have to
submit.
submit the
No,
particulars.
it is my duty to inform the court.
Yes,
Today
Definitely.
is the
Then we can reflect.
Yes, after long pending,
But,
today
so
the matter
if-
has
if
come up.
when-
So it is my duty to point out.
MSDB, so and
So he can
yes.
inquire the matter if he failed to ascertain then.
During the deliberation, it is submitted by MSDB that the sole respondent, no?
Yes.
Sole respondent is also
Both
like
are brother and sister.
pendency of this case. Accordingly, she is asked to provide the date of death, etc. to the appellant, and appellant will take necessary steps in substituting the legal heirs of the sole deceased. Is a matter of. So I have mentioned here.
Lord.
You may provide us every details. Every details can be.
Lordship. In the event of my lord providing date, Lordship, I will file my lord application. Lord.
I have asked the other
Yes.
side
No,
to provide the date.
it is also their duty to ascertain as because both
No,
are
no,
living
no, this is
together.
UDT as per
They
rule
told us both are living
10A.
together.
This is UDT. This
It
is a Supreme
their
Court
duty
judgment
to
pending,
ascertain,
Lordship.
But as the knowledge has come from
yes.
your
My
side,
lord,
then
this
you
is the
should
judgment of the
provide
Honorable Supreme Court, Lordship.
She should provide the details.
Recent judgment, Lordship. Unless the date is informed to the Honorable Court, Lordship. The,
How we can be.
yes,
I have already instructed the as per order to
All right.
provide the date of everything, and in that part you can also make an end.
Lordship.
On the next date, you'll just provide us.
So
my lordship.
my information may kindly be recorded that the respondent.
Yes, I have already recorded that you have
Yes.
informed the respondent number 2 had already died. However, yours
Yes.
asked.
All right, Lordship.
Let it come in the month of November.
Well, before that, because my lord, then limitation will run, Lordship.
No, once you file your application, it will be counted.
Without
from that day
specific
only.
date, I cannot file, Lordship.
No. For others, oh, this one.
Yes, Lordship.
Obviously, they will file there.
Yes.
On the next day, you file all these things. Details about his date of death.
Yes, no problem.
All right, Lordship.
My lord, limitation is barred by only 75 days, my lord. It is for the first time, my lord.
Issue notice.
No.
We are issuing notice here.
Yes.
At MSL Sharma, Milan Council for the it's an application section of the issue notice. There is 2 days to list it accordingly in detail. Okay, it takes steps within 7 days. We are listing it after the
Always me.
Lordship, this is the listed first today, Lordship. There is an IA for delay containing 39 days, Lordship.
39 days.
39 days.
But we don't have any alternative. Other side, this is you are for the company.
Company, Lordship.
Issue notice, same order.
Same order.
Same order. You are Mr.
Ekakoti, Lordship.
Ekakoti.
Ekakoti.
So listing it after puja, you take steps for the notice to serve on there.
Lordship. Obliged.
Sharma, you are
Other
here.
side not
Other
available.
side is not here. I
Yes, my lord. Let the matter may be after adjourn.
Application.
Yes, my lord.
Hard MS L. Sharma, you are counsel for the appellant. None appears on call for the respondent. Due to absence of the respondents, the matter could not be heard. The matter immediately after petition as an edit. It is a case of 2016. That's why we're taking this matter.
Yes, my lord.
2016. So try to proceed with the case. Yes, you have something. 40.
Lordship.
John.
On behalf of Mr. Ek Honikor, Lordship.
You are Mr.
On behalf of Mr. Ek Honikor.
No, whatever.
B.
You are
Deori,
Mr.
B. Deori.
B. Deori. Appearing on Mr. Pipa, we have
Ek Honikor.
A. Khanik.
Respond number one.
Pass.